Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case.
From safe.
Literally not true.
Dati mihi Anglican for his verbis Latino. I didn't ask you to interrupt me.
Is that correct?
How am I supposed to get my lunchtime in if the judge rushes everybody back to the courtroom and kicks things off before she said she was going to? How am I supposed to get my my beauty rest on the lunch break? I can't. She's doing the proffer right now. All right, but before we have a proffer, welcome, first of all, Zimmy, you were first in chat. Let's see. Okay, Let's see. Okay, so now we can't take our, we were going to have a little court watcher explain what was happening, but now things are going on in court, so now she has to go back to court and watch that. So, Zimmy, you have the internet. Fix it, because the judge is underway. And so now I have to ask you guys a question. Do you want to go back and watch the proffer, or pick up where we left off, or pick up where they are right now? We could watch the proffer on 1.25 speed and catch up in just a couple minutes, if that's all right. I think that would be more fun. Watch the proffer. Jump to right now. We are, let's see, time-wise, they've been going for about 5 minutes. That's my fault. So yeah, they're 424.18 all the way up to, yeah, the phone's ringing. Let's see who this is.
Call from
Kayla S.
Kayla, our court watcher. How are you doing?
Hi.
What is going on?
Good, how are you?
Does this judge not take a lunch?
I know, seriously. The good thing is that it's easy to go in and out, and everybody has. So I should be able to talk for a little bit before I go in. So
awesome.
I should be fine.
Awesome.
And I can always rewatch it later. So.
What happened on lunch? What's going on? I guess I need to say, what is going on?
So it sounds like the defense has been putting like a lot of motions in and stuff like that, and the defense and the prosecution are not happy with each other at all. The court's trying to be restrained as much as she can, but I feel like she is also a little bit irritated because one of her comments this morning, right when we started, was she's got other cases, and in the last 3 weeks, they've sent so many motions that it's been hard to give adequate, I guess, input or like research into the motions that they've put forth. So there's just an irritation there. And then what happened at lunch, I rewatched because I saw her coming in, but I left stupidly thinking that they were just going to do something quickly, not like that, and then go to lunch like they were supposed to, but that turned into a way crazy situation. So
we have a witness who skipped her subpoena for the state, is now being held in custody.
Yeah.
$1,000 bond if she can afford it. She'll be back on Tuesday, one way or another. And now we're going to jump to a proffer.
Yes, and the county jail is connected right to the courthouse. And Grand Rapids, for anybody who doesn't know the area, is about an hour and a half away. And it's probably 70, 80 miles. So if she didn't have a car, that's going to be a very hard way to get back and forth. That's probably why they did that.
Well, luckily the jail has a transport vehicle and they can arrange that. So now she's
really?
got it covered.
Oh, that's awesome.
The jail will transport her, sheriff's will, if she's in custody.
Oh, that's nice. Hey, you know more than me. But
yeah, wow. Yes, she's in custody. She says she can't afford the $1,000 bond, so she'll be held until she testifies. It's sad, but this is the way the court works. So you don't joke around with the subpoena. All right, we'll let you get back.
Absolutely not.
We'll let you get back in court. We're excited to have you in court today. Thank you. I've been reading some of your tweets and letting people know what's going on with the jury and everything else. We'll probably get into that more if we get a chance, but we're behind on this proffer a few minutes. We're going to speedily catch up.
Okay, sounds good, and I will talk to you afterwards.
Awesome. Thank you so much. Appreciate the call.
Of course.
All right.
Thanks.
Bye.
Bye.
All right. So we are going to watch the proffer as this happens here. It is on 1.25 speed. There is some spice here, so it's going to be hot and spicy, and it will be a little bit fast. But that's the way it's going to roll today as we get caught up. We're just about 5 minutes behind, so give us, in the next 15 minutes, we'll be caught up. So when court starts, we'll be ready to go and back on the normal speed. But wow! Give me a second. I'm just queuing everything up as we speak. I'm still trying to eat my lunch. I've got I had some leftover lasagna, and then I still was hungry, so I went and got some fried rice, microwave fried rice, both of which I seasoned with Sticker Mule's mule sauce, which I'm a big fan of. Okay, go forward. Holy cow, it was like 20 minutes back. That would never work. Okay, there he is. 3, 2, 1. Looks like this one starts nearly cold turkey as well. We just got thrown into the proffer.
The gas chromatograph?
That's correct.
And obviously you're aware at some point in time, you worked for Barker and Herbert Laboratories, is that correct?
At one time I did. I retired in 2017, June of 2017.
And if you have knowledge of this, I don't know, does Barker and Herbert have a file retention policy in place?
They tell me they only had to hold the files 10 years.
And so that would have been from the date of your testing in 2007 until roughly around the time you retired in 2017?
Yes.
And they would have destroyed their in-house file, is that correct?
That's correct.
And what information was contained in that in-house file?
Would have had the chromatograms. There would have been a continuity from Mr. Shinsky. There would have been a return postal card showing the number and the address going to Mr. Shinsky when we returned the samples. There would have been any notes would have been on the chromatograms. Near as I can recall, that covers most of it.
Okay. So essentially, if I could boil it down, it'd be kind of like we have some information that's related to chain of custody of the evidence, is that correct?
That's correct.
And then we have the chromatograms, which are essentially just the printouts from the machine, is that right?
Yes.
But those printouts actually require your interpretation, is that correct?
That is correct.
And you had to review those in order then to memorialize them in your report.
Yes.
And the findings of those chromatograms are in fact memorialized in the report that you have been provided and you have reviewed, is that correct?
That is correct, yes.
Okay, all right. Just a moment, Your Honor. Okay, I have no further questions.
Thank you. Mr. Mueller?
Morning or afternoon, Mr. Balliet. How are you?
It goes fast when you're having fun. I'm doing well, thank you.
Good, good. You've been retired now for 8 years, roughly?
Almost 8 years.
Okay. Sure, that's good. All right, let's talk about, just real quick, your career. How many of these chemical tests, these analyses, this gas chromatograph, mass spectrometry, GCMS tests have you run in your career?
Well, I've been doing it for 35 years.
Clearly thousands.
I'm going to give a wild guess right now, in excess of 50,000, somewhere between 50,000 and 100,000. That will include also the standards, the system checks that we run with samples. Will also include clean. Got to think of the words. Clean vials with solvent in them, the carbon disulfide checks.
Even looking at this, do you remember this test specifically?
Do I remember this test specifically?
Yes.
All I can say is that I testified on it once, and...
Other than that, you have no recollection, do you?
I remember the red towels. I remember testifying.
Okay. Let's talk about how you go about finding your conclusions, okay? First of all, I want to show you what, and this is part of the supplemental brief and part of the objection, Your Honor. Exhibit number 1 was the test on the red towel. You have that in front of you? I can give it to you.
I do. I have a copy of it.
That's your test, right? And what happens in this test is you put down the results of testing, am I right?
That's correct.
The results of the testing was test on extractions from the samples revealed gasoline residue present on sample 2A and sample 2B. You see that?
I see it.
And then we know from the inventory of samples, we're talking about basically the red towel from the laundry, from the washer, right?
Yes.
And the red towel from the item number 2 bag of laundry, right?
Yes.
And when you do this, you run it through this GCMS machine, right?
Well, there's procedure done before we ever get to the GCM.
You've got a lot of procedures you have to do.
That's correct.
And then you have to make sure you document those procedures.
That's correct.
Right? Just part of the scientific method, the documentation.
That's
fair?
correct.
Then you get the results on all these charts. Am I right?
That's correct.
All right, I'm going to show you, and I'm going to hand to you, Your Honor, just a report from Troy Ernst. You know who Troy Ernst is, by any chance?
I beg your pardon?
Troy Ernst?
I do not know Troy Ernst, no.
You tell me, this is a report from Troy Ernst. He did a GCMS test on some sweatpants, and he generated a report. And what I want to do is talk to you about the report he generated and what those charts are. First of all, we know, because I subpoenaed your office, exhibit number 2, that your office has no more records. Am I right?
That's what they have told me. I've been there and looked, and I have not found it either.
Okay. So, if we go to Mr. Ernst's report, are those the kind of charts we're seeing up on the screen that are typical of this GCMS machine, this testing?
Those are chromatograms. I don't know what instrument that is.
Okay, but that's what you were telling us about, right?
Yes.
That's what generated. You actually have to interpret those, don't you?
That's correct.
I mean, it doesn't come up with an emoji, thumbs up, positive, does it?
Don't have one.
Thumbs down, negative, does it?
Don't have one of those either.
Or red light, no substances, right?
No.
Green light, positive. You have to do that, right?
That's correct.
It takes your intelligence and training.
That's correct.
And you don't know what those charts said on this particular test, do you?
On which test?
On the test of the red towels. All you're doing is reading your conclusions. Am I right?
I don't know which test you're asking about.
Listen to me very carefully.
The test for the red towels?
The test that I had done or the test that Michigan did?
I'm going to take the Michigan State one back.
Good choice.
Yeah, I think he's talking about the one you did.
We're going to talk about your testing on the towels. Are we clear?
Okay.
We're clear.
On the testing on the towels, you had charts very similar to the 39 pages of chromatograms we have here, right?
I don't know how many he had, but we had chromatograms and we had ion chromatograms,
Okay.
breakdown of the particular peaks.
Okay. So the bottom line is you have to interpret all of that, right?
That's correct.
And that's how you come to your conclusion there was positive for gasoline on those 2 samples.
That's correct.
And without that, right now, you don't know what caused the positive.
In order to make the determination, we use overlays because we are required by ASTM, the procedure we use, to make visual comparison with known ignitable liquids to be able to make that determination.
You don't have those visible comparisons, do you?
I do not have them.
You have no records or what we call data. That's called underlying data.
Data for the case.
Let me finish.
Testify. This has got to stop.
This is cross-exam. And he can say the argument for the jury.
Both of you. This showmanship you're both doing needs to end, and the drama needs to end now. So please, don't even start asking a question, Mr. Mueller. I'm not done, okay? Give me a minute. This witness is just here because, through no fault of his own, documents were destroyed. We have a legal ruling. There's no reason to be getting emotional with this witness or for any other reason.
Mr. Bathett, you don't have what we call the underlying data to support your opinion, do you?
I do not have it with me because it does not exist.
Because it doesn't exist. And if you don't have that, you don't know what interpretation you made 18 years ago that led you to that conclusion, do you?
Well, do you have to assume then I'm either lying then or I'm lying now?
I'm not assuming anything, sir.
Sure.
I'm just asking. You don't have the data, so you'd just be reading that.
You've asked that a number of times, and I've said I do not have the data.
So you would just be reading the conclusions. Fair?
Yes.
No more questions. Thank you.
That report you have in front of you details the process and procedure you used. Is that correct?
It identifies the procedures, yes.
And you are still to this day intimately familiar with those processes and procedures, correct?
I am, yes.
And you took the results of those chromatograms, and the point, I guess let me ask you this way, the point of writing that report is to memorialize the data that you observed in your findings, is that correct?
That and to let the client, and in this case Mr. Shinsky, know that something was identified in some of his samples that we qualified or identified as gasoline residue.
And even in that report, you don't quantify a level of gasoline or anything.
We do not.
You are just indicating that there is the presence of gasoline.
That's correct.
And so basically all this chromatograph the GCMS does is simply identify that the substance is present. Is that a fair statement?
That is a fair statement, yes.
And then you take that it's there and then put it on your report basically saying, I found gas.
We say we found gasoline residue.
For gasoline residue?
Yes.
Right, I'm summarizing, but that is essentially, the purpose of your report is to memorialize all of your findings.
That is correct.
And you testified, you said, or you've had, I'm sorry, not testified, strike that. Somewhere between 50 and 100,000 cases you've analyzed.
I'd have to figure out how many I have done over 35 years. Right off, I do not know.
Fair. But the whole point of that report is to be able to refresh your recollection should you be called to testify in court. Is that fair?
Yes.
Thank you. No further questions.
So you do know the difference between underlying data and methods and procedures?
I do.
Okay. There is a significant difference, isn't there?
There is.
The method you're talking about is we use this MSGC and we prepare it, and you describe those methods, right?
I identified the methods in the report.
Right. But you can't identify the underlying facts and data that you interpreted to get to the result, right?
I'm going to object. Your Honor, this has been asked and answered. I think he's asked it ad nauseum. Last time he was asked it again.
Because I can follow up.
Yes, one more time.
Okay. And because you don't have the underlying data, it would be unfair for me to try to question you because I don't have the underlying data. Do you agree?
Well, would you have used the underlying data previously?
Can I get an answer to my question? If I don't have
Recollection, so I'll have you move on.
Okay. I don't have anything more for you. Thank you.
Thank you.
So the gloves are coming off here.
Normally, did you find out about this, that the records had been destroyed? Did you reach out to the company where you worked to get those for purposes of testifying?
Yes, I had received a subpoena sometime in 2024. I think the case was going to go around 2021 also, but I did not get any subpoenas at that time. In 2024, I had gotten a subpoena, so I contacted the company to be certain that I could get a copy of the report. Normally what I would do would be to go over to the laboratory and do the copying myself so that I had everything that I was going to need for testimony. And they indicated to me at that time that the case no longer existed. So when it was destroyed, I have no idea. But they informed me that they only keep them for 10 years.
And I'm not a science person, so you'll have to forgive my naivete on my questions. But would you normally, there was the graph that was put up, would that be something normally, was that part of the data that you used to reach your ultimate conclusion that there was gas involved?
The chromatogram that was shown on the screen is similar to what we would have had. We have I'll call them charts, but they're charts of chromatograms, and with GC mass spec on those charts, and you notice there were peaks and valleys. Yeah. On those peaks and valleys, we can go in to the computer, ask the computer to tell us what are the ions that make up this particular peak, and then that's the mass spectrometry part. The ions are indicative of what makes each of those peaks, and the ions are all going to be different for each of the peaks. That's what I would have had in the file. Yes, all of the
produced at a hearing or something. You normally have that.
I always have it with me. Very seldom in testifying over 35 years have I ever had to show it to the jury. I can think of one case. There was one case in Michigan that the attorney wanted me to show the jurors the chromatograms. They made copies of all the chromatograms and the extracted the ion sheets of the components, and the jurors looked at them and were able to come to the same conclusion that I had reached by using plastic overlays that I had supplied.
So you look at that with the word I can't pronounce, and then you make an interpretation off of that data of in this case, gasoline on an item. That's the data, that graph that we saw, or something like that from Ernst, something similar to that would be what you would normally, that's what you're looking at, and then with your expertise, you look at that data and reach a certain conclusion.
Well, the reason I mentioned the chromatograms that we had provided to the jury in this other case was because they were able to take the overlays, the plastic overlays, and put them, plastic overlays being of known ignitable liquid residue. I think that case was also gasoline. But they were able to take those overlays and put them on the chromatograms that I had done and make the comparison. And that's exactly what I would do. It's got to be straightforward enough that it's identifiable to even those that would be serving on the jury.
So in this case, the jury wouldn't be able to do that, though, right? Because we don't have it.
We don't have the data that does not exist.
just looking through my notes there. Anything else, counsel?
When ordinarily you give your information to the requesting party, so in this case the insurance company who requests you test these items, do you send those chromatograms to them as well?
No, not unless they would ask for them, and I don't recall ever having an insurance company ask. Many times after litigation starts, one side or the other will like those chromatograms. They want copies of those chromatograms, but generally we do not send them directly to the insurance company because they have no idea what they're looking at. So,
thank you.
So is that the entirety of what, I know you don't recall reaching your conclusions in this case. You have your report of the conclusion, but this graph document you're describing, is that the totality of what data you would, or facts that you would have used to form your opinion that there was gas?
Yes, it's based on gas chromatography.
It's based on that, and in this particular case, the results of the gas chromatography.
Gas chromatography coupled with mass spectrometry.
Okay. Did they destroy that data too?
It's gone.
The second one?
It's just that
And those are the
chromology.
pieces of data you used to reach your conclusion here?
Yes.
Okay. Anything else, counsel?
You want legal argument?
First, I want to see if anyone has any more questions of him.
I know no questions.
As far as you know, sir, that underlying data is gone forever. Best of your knowledge.
The model that I had asked for at the laboratory no longer exists.
Thank you.
Okay. Brief arguments, counsel?
Your Honor, this isn't even a close call. MRE 703 specifically states the facts and data in the particular case which an expert bases an opinion or inference shall be in evidence. The use of the word shall indicates a mandatory imperative directive, and that's Burton versus Reed City Hospital Corp. 471 Mich. 745 at 752. That's a 2005 Supreme Court case. The other case that talks about it, it necessarily follows that an expert witness may not base his or her testimony on facts that are not in evidence. People versus Unger, 278 Mishap 210 at 248. That's a 2008 Court of Appeals case. We do not have the evidence. He has to have that to interpret to get to those conclusions of a positive gas test. And why do we require that in MRE 703? Because, as the Supreme Court stated in People versus Kowalski 492 Mich. 106 at 121 in 2012, expert testimony without a credible foundation of scientific data, principles, and methodologies is unreliable and thus unhelpful to the trier of fact. Not even a close call. People versus Fackelman stated that an expert's opinion must be based exclusively on evidence that has been introduced into evidence.
Okay. Thank you. Mr. Blair?
The issue I heard with every case that the opposing counsel decided is those are all analyzed within the concept of the confrontation clause. The confrontation clause requires that a testifying scientist that prepared the report be present in court to testify. Obviously, he's here. He did the entire process, so the confrontation clause is not what's issued here. What it seems to me in reading that, first of all, it's facts or data, not facts and data. They're mutually exclusive with one another. So the facts are present here in court today. He's here to testify. The jury, I think, should be able to, Mr. Mueller can cross-examine him about the lack of the chromatograms. I don't think it renders his opinion and findings unreliable. He can question.
703 is really clear. Your witness seems to be testifying as credibly as he can. It's not his fault that evidence got destroyed, but his opinion was based on these two different manners of whatever you call them, but we don't have those. I mean, how are you getting around 703 here?
Because it's memorialized in a report.
That's the conclusion. The report is his conclusion. And so we're looking for the data supporting his report, which normally we would have, but by, a very unfortunate, no one's fault,
I understand that, Your Honor. I still think it goes to weight, not admissibility. He is a qualifying scientist. He is able to testify about the procedures that was used, what he did, and the results. But I think it goes to weight, not admissibility. I think it's admissible. I think he should be allowed to testify in his report. The jury can give whatever weight it wants. Mr. Mueller can cross-examine him ad nauseum about the fact that those chromatograms are missing and he can't do his own independent comparisons of the chromatograms and so on and so forth. But at least the report should still come into evidence. I think it's a valid record of everything that was done, and he can at least admit the report, and the jury can give it whatever weight they want to decide it belongs to it at this point in time. If they want to give it no weight because the chromatograms are not here, fine. But they can give it whatever weight they feel or they deem is appropriate. The foundation of him being an expert is not in question. The methodology he used is not in question. And his findings are still present. And I think that's important. And he can testify about the process that was used and how those chromatograms would be reviewed in arriving at his content, at his final results. Just because those chromatograms aren't here doesn't mean that those results should not be available.
Where do you see that in 703? Because I'm reading the opposite, that his opinion is based, he said, on two different things, neither of which we have. And the evidence in the particular case, or facts or data of a particular case must be in evidence.
Facts or data.
Facts or data.
Facts. We got the facts. He's testifying as a fact witness. He is testifying to facts.
So he's not going to give his opinion about
no, that's in his report. What I'm saying is he's giving facts about what he observed and facts that he saw. Is this facts or data?
Because I don't understand that. He said again, I'm not a scientist, but he said his conclusion is based upon these graphs that he does, and he doesn't have the graphs.
I understand that, Your Honor. That's been beaten down here ad nauseum. I completely understand these graphs are missing. If I had them, boy, I'd really like to have them save us all this 11th hour challenge to our evidence again in the middle of a trial. So, the problem with this issue is, Your Honor, there aren't really any specific cases that directly address what's going on here. This is kind of a novel issue. I did research last night. I think I at least supplied a lot of the court at 9:30 last night, of which the defense has supplied none. At 9:30 last night, basically trying to find something that would support this. I can't find anything. Because chromatograms apparently are something that no one cares about when experts render an opinion. And so I think that maybe is somewhat telling about this issue, is that it's not necessarily it goes to the weight, not the admissibility. It's not necessarily the underlying data. That doesn't necessarily supply the entirety of the underlying data, I should say, that the court needs to render a decision.
Okay, well, first off, I don't believe that this is a confrontation issue.
This is huge.
I don't believe a machine makes testimonial statements, so we don't have to go there. But try as I may, after listening to this testimony today, I can't get around 703, which leaves the court without discretion. And the court is obliged to, and I quote, an expert may base an opinion on facts or data in the case that the expert has been made aware of or personally observed. The facts or data must be in evidence or, in the court's discretion, be admitted in evidence later. He's identified two sets of, whether you want to call them facts or data, that he's put into evidence or that he reviewed that form the basis for his opinion. Through no fault of anybody here, the company destroyed that data, so we don't have it, which leaves the defense without the opportunity, apparently according to the rule of evidence here, to effectively cross-examine. I don't know that there's nothing in the rule that leads me to believe that this is in fact an issue of weight. The witness has been very clear. That's what he interpreted, that's what he had, but we don't have it here today, so I'm going to exclude the evidence.
Yeah, I suggest one other avenue, Your Honor.
Okay.
Could we admit the record as a business record, just not have him testify to the interpretations of his findings? I believe it would be a document kept in the regular course of business at Barker Analytical Laboratories. It could come in as a business record. However, he's not allowed to give us any expert testimony about what he did. He can simply admit the record. The jury can do whatever way they decide.
Your Honor, that's absurd. He's the expert who's going to testify that the gasoline was positive on the red towels. To try to backdoor this in where he's not even allowed to testify, but you can read to this document to the jury. Come on. We've supplied. I'm not even belabor the point. Thank you.
This is huge.
I mean, Mr. Blair, that would require some research. I'm not going to go on the fly on that right now, but...
Well, then I'm going to ask the court to at least enter an order that Mr. Valley's not being referenced by the defense in a closing argument, in any arguments or the red towels or anything along those lines should not be mentioned by the defense, because I've heard a comment earlier about how if we don't present certain evidence, it's going to be, and I quote, rammed down the throat. So I don't necessarily want that, this to be brought up. I think that's fair and appropriate given how this has played out.
Okay.
That you tried. One party gets up and makes promises to the jury in opening statement.
I think it's fair to comment on what wasn't done in a case, but if he says it wasn't done, that's one thing, because that would open the door to that's dishonest, because it was done. But just
that the jury comes in a closing argument. And the problem is we made no promises about what the jury was going to hear from this one.
Right.
So it seems only fair given how this has played out in court. There's a fundamental fairness issue here as well, that it seems to be falling on its face.
Really, Mr. Blair? Because you keep presenting this as this last-minute issue. This is your evidence. You're the proponent of the evidence. If you go back and look at the transcript, of this matter in 2021, we discussed all of this. And I said, assuming the prosecutor can lay the foundation, I'll allow it in. So you've been on notice, I've been on notice, we're all on notice. It's a rule of evidence. It's a standard rule we have to follow. That's my ruling. So I don't know where this is about fundamental fairness. If the it happens in every criminal case where the defense highlights what evidence you didn't hear. And so if they want to say you didn't hear any evidence of the towels, that's fine. Now, obviously, if they go on and say the prosecution never had them tested or something like that, that would be completely inappropriate. But to highlight for a jury evidence that they don't hear in a case happens all the time.
Well, essentially, if they get up there and say you didn't hear from the testimony of Craig Balliet, well, you've excluded it, so it leaves us in a kind of an unattainable position. I guess that's where I'm kind of going with this.
Well, I guess what we could do is when we get to that part, you can provide me in advance of what you intend to say to the jury, and we can go from there, if it's as it relates to Balliet.
Each other's playbooks out.
Okay. Well, then I could just order that you not bring it up. I mean, that's what you'd rather.
If that's the alternative, we'll make an outline, Your Honor.
Yeah, that's all I'm asking.
Yeah, no, I get that.
Commenting on a witness that wasn't allowed to testify by court.
No, I get that.
I mean, that only seems fair.
That would be fair if it's because he couldn't lay the foundation for the opinion.
Let's worry about the closing arguments later.
Thank you. And Ms. Balliet, if I was a little chippy with you, apologize.
Anything else then, counsel, before we...
I do have one issue, Your Honor. So if the defense brings up any testimony that Ms. Stermer smelt or had Mr. Todd Stermer was down there leading this furnace, which is obviously not the fuel oil that was found on those towels, it could come in as impeachment evidence.
No, I mean, I think there may come a point where impeachment evidence could come in.
Yeah, so if defense presents witnesses that are going to say that she was down, that Todd was down there bleeding the furnace, and if defense starts then putting the fact that there was this fuel oil that was on this rags and she was down doing laundry, I certainly think that at that point we need to revisit this for impeachment evidence, and then we would ask to admit it under a business record, as I've already brought in Mr. Balliet from out of town. So I just want to put everybody on notice. I mean, you can't then go ahead and start arguing after the court's excluded it, that that's what happened when we have obvious knowledge that that's not what occurred.
Defense, just be on notice that you may open the door to this coming in as impeachment.
All right, but I want this for the record. There can be no opinion for any purpose that he hasn't laid the foundation to say what he did. To try to get some record in under the business record exception for impeachment purposes where there's no evidence of what he did, how he got there, is absolutely, it's inconsistent with the rules. That's not what that's for. You have to lay the foundation for any expert opinion.
Right now we're here on the 703 issue. I've ruled on that, and so we'll have to just play other things out as we go.
I just wanted to report that we would intend to admit under impeachment evidence then. Okay. Thank you.
Anything else, counsel, before we bring in the jury?
No.
I have one question, Judge. If she's talking about, when you talk about impeachment, like bringing Mr. Balliet back in on the witness stand?
I don't know if I'm addressing him or you, Your Honor. I would have to address that back. If they're going to put witnesses up on the stand, or Ms. Stermer's going to take the stand and says, I smell fuel oil, and I washed it, and Mr. Todd Stermer was working on the furnace the night before, then I think we have the opportunity, the door has been opened, where then we would be able to then cross-examine and bring that in as impeachment evidence and say, isn't it true that that tested positive for gasoline and not fuel oil? That's all I'm saying. I'm going to be asking for Mr. Balliet to be released on subpoena, so I don't intend to bring him back unless the court were to direct me or order me to bring him back if we need him for that impeachment evidence.
How about if we get there, someone get me some law on whether the evidence that's been excluded under 703 can then be brought in for impeachment? I don't know. I haven't done that.
The only way they would try to do that is to backdoor it in through Jim Shinsky, who then they're going to read question and answer about his interview relating to that. All of this stuff now, given his opinion, as I put in my objections to their exhibits, is irrelevant. The red towels are irrelevant. His CV is irrelevant. His appearance is irrelevant. The red towels have nothing to do with this case, given that you can't connect it to gasoline.
I'm not here to rule on the red towels right now. I'm here to rule on the 703, which I've done. So
that's the opinion about the red towels.
They may have some reason to introduce the red towels. I don't know.
Give me a second here to clean up.
So may I let Mr. Balliet off of the subpoena and maybe leave then?
Yes.
Okay.
Okay, what just happened there is huge for the defense in one way. The gentleman who was just on the stand, who was in the proffer, giving the proffer, was the guy who did the gas chromatography testing of the red towels that were in the washing machine or the dryer. It's in the laundry in the house. that had gasoline on them, according to the tests. But because he did the tests so long ago, when he was finally subpoenaed in this trial to go back and get the information to bring it to court, the company that did the tests had already thrown away. It had been over 10 years. It was gone. Under Michigan law, an expert has to have that base material available, and it was not. So defense is not, or the state is not allowed to say, oh, by the way, guess what? She was washing towels in the basement. They're covered in gasoline, not kerosene, not fuel oil, gasoline. And that is a huge, huge win for the defense. That's not coming in right now, unless they can find some way around it with some sort of business document, which doesn't sound very, very reasonable. But that was information that was in last trial and is not allowed in this trial. So yeah, that's terrible. That's terrible for the state. So now they're trying to find a way in. They're trying to say, just bring the document in. We won't question the witness. He won't elaborate on anything. He'll just say, this is an official document kept in the course of business. Here it is, jury, face value. The judge says, I don't think so. You'll have to bring a little more support than that, because the way the law is written, you have to have that foundational material, and you don't have it available. It's not your fault. It's not the witness's fault. It's just gone. So you can't use it because defense can't examine it. I don't think we have time for this. Hello?
Yes. Yes, hi, this is Maria, and I'm calling you from Your Choice. Getaway, how are you?
Getaway? Say it again? Hello?
Your Choice, yes.
Okay.
Okay, well, anyway, I am calling in regards to a large amount of travel credits you have in file. And I see the activation fees were covered. You just never booked dates and travel. So would you mind me asking, you do still interested in traveling at some point in the future, right?
I'm sorry, can you speak just a little slower?
And Dr. Mark,
okay, so do you have a plan to travel in the near future, right?
Thank you. Good afternoon, Dr. Mark.
Sorry, I'm in court right now.
You and I have never met, but we've talked a couple times on the phone, right?
Yes.
And I think we even did a Zoom at one point.
Hello?
Remember that during COVID?
Yes.
I'm in court. I can't hear you.
About your autopsy report and the results, okay?
Okay.
I want to just first begin with, if I can, something I made a note of. You said when the body came to you, it comes in a sealed body bag, right?
Typically they do. I don't recall if this one was or not. I'd have to look at my report.
But the reason it's sealed, you said it's important that it's sealed, right?
I mean, generally they're sealed so that when I open the body bag, I know that there's nothing that has happened to the body since it was put in the bag until it was opened.
Right. Important for chain of custody issues, isn't that right?
Generally, that would be the reason.
Okay, because as a forensic scientist, as a forensic pathologist, you know you're in court and you have to establish a clear record of this was the body at the scene and the evidence with it, right?
Yes, I mean, that's essentially the reason, as I stated before.
And then when it gets to you, you open a bag and we can make sure that what was at point A is at point B.
That would be the reason, yes.
That's why you document what's at point B when it gets to you. Am I right?
That is correct.
All right. Do you know typically if the medical examiner's office has a policy, like where you work, you do things for autopsies for different counties, don't you?
That is correct.
Where the ME's office has procedures and policies where evidence can't be removed from the body unless the medical examiner's office signs off on it.
Yes, in the counties where I serve as the medical examiner, the body is my jurisdiction and anything that's on the body is my jurisdiction at the scene. And if something needs to be removed for some reason at the scene, then generally it is done at my office's authority.
And you would have a paper trail because you don't want critical evidence disappearing later on, fair?
I'm not sure. I mean, it would be documented in our report if there was something at the scene that was removed that was thought to be significant.
Okay. You don't have any record of anything being removed at this point in this case?
I wasn't the medical examiner in this case, so I'm not responsible for that. I was just asked to do an autopsy and give an opinion to the Van Buren County Medical Examiner's Office.
Okay, so let's talk about these opinions. I want to talk about, obviously, the data you had included there was a fire and Mr. Todd Stermer was severely burned and ultimately perished. Fair?
Yes. I mean, I'm sure it was more detailed than that, but that was 18 years ago. I don't recall all of the details.
Then the next piece of data you had was there was some evidence that he had been run over by a car.
Yes.
Specifically a van.
Yes.
Did you know it was a Ford Econoline van from 1993?
I don't recall knowing the specifics.
Right. And the body then gets to you, and you talked about the thermal injuries, and we'll talk about that in a minute, but I want to focus right now on what you call the blunt force trauma injuries. And I want to go to your report, if we may. Can you see that?
Yes.
And you have your report in front of you, right?
Yes.
First thing you had was lacerations, you said, right?
Yes.
All right. Those lacerations were to the top and the side of the head, correct?
To the top, to each side of the head, and one to the back of the head.
If I say BFT, blunt force trauma, fair?
Sure.
So when we have 4 lacerations, right?
Yes. Yeah, that's what the report indicates.
BFT. What else can that stand
for?
Right? Correct.
Bigfoot.
One on each side of the head, on the ears, you said?
They were on the side. One was on the left side of the head, above the level of the ear. The other was on the right side of the head, above the level of the ear.
One's on the right, one on the right side. Where was the last one, on the back of the head?
Yes.
So I put those down correctly?
I can't see it.
Counsel's in the way.
Yes.
All right. Then we had, I think, linear abrasions, right?
Yes.
Counsel's in the way. She's standing, blocking the shot.
Like you fell on the pavement.
I think I specifically stated that they were like scratches or scrapes on the skin.
Okay. And 3, we have rib fractures, right?
There are rib fractures, yes. 3 rib fractures.
2 on the left side?
Correct.
They were ribs 3 and 4?
Correct.
1 on the right side?
That is correct.
And that's rib 4?
It was rib 3.
3, okay. Those were the only blunt force trauma injuries you saw, right?
No, as is listed in my report, there were, or letter C, there were lacerations on the right shoulder, upper back, left upper arm, and lateral left back / chest.
Okay. So lacerations to the back and chest, or just the back?
To the back, to the left upper arm, and to the lateral left chest or back. It was on the side of his torso, depending on what you wanted to call it. It was either his lateral chest or his lateral back.
Okay. Now, those lacerations to the head, you said, those 4 were, I believe, and it's in your report, I believe it's called minimally depressed?
No, the minimally depressed injuries were fractures of the skull. The lacerations of the skin were just splits.
No, I apologize. They missed. Skull fractures we missed, right?
Yes.
All right. Those 2 skull fractures were minimally depressed, right?
Yes, that means they were sort of, I don't even think I called them fractures per se, because they weren't like full breaks through the bone. It was just the outer surface of the bone was inwardly dented, for lack of a better word.
I've been told by other doctors, medical examiners, a depressed skull fracture can be described as if you took your finger and threw some icing on a cake a little bit. Would that be about right?
I mean, it's basically, it's just a dent. You know, it's an invagination of the surface.
Those skull fractures certainly were not life-threatening, were they?
Those fractures in and of themselves, no.
Okay. Those 4 lacerations, and by the way, those skull fractures you say didn't penetrate the skull, and we didn't have any brain damage, did we?
No, there was no obvious injury to the brain.
Okay. In terms of other organs, there was no obvious injury to the heart. You would have noted that.
No, there's no heart injury.
There are no obvious injuries to the internal organs of the gut, liver, spleen, kidneys, nothing.
That is correct.
Okay. So we don't have organ injuries. In terms of fractures, you described these 2 minor fractures. We don't have any other fractures, do we?
There's fractures of the skull and then fractures of the ribs.
We'll talk the ribs. You said at least the ones on the left for sure are consistent with what you find when people are doing CPR.
Yes, they could be due to CPR.
Okay. And even you said it's uncommon, the one on the right, but you can't rule out that it could have been done by CPR. Fair?
That would have been very unlikely that a posterior rib fracture would be from CPR.
Let's say the one that wasn't done by CPR was caused by impact with a vehicle. That's not life-threatening, is it?
No, that fracture in and of itself would not have been life-threatening.
The lacerations to the back and the upper left arm, those weren't life-threatening, were they?
Unlikely. I mean, lacerations, especially of the scalp, and they can bleed. So if they're not attended to, they could bleed enough that you could lose blood. And it could be significant, but of themselves, they're not usually immediately or significantly morbid.
Okay. I'm going to go look at these lacerations because I was told you took autopsy pictures, didn't you?
Yes.
All right.
I didn't. They were taken at my direction by an assistant during the autopsy.
Okay. Give me a second. I'm going to show you a few autopsy pictures that have already been labeled as Exhibit H in ours. They're coming from your autopsy. You do take pictures of standard part of autopsies, right?
Yes, during autopsies we take general photographs of the body and then photographs of anything that we think is significant.
I'm going to describe them right now.
Okay, you're not going to show them though?
I'm going to show him if he says he took pictures.
Okay, I just want to make sure, and then make sure you don't show them.
Your Honor, foundation needs to be laid. He said he did not take pictures. So I think the foundation needs to be laid that these are in fact pictures taken. Or
I'm going to show him, if you don't mind. I'm going to approach. You've seen pictures of the autopsy?
Yes.
H1 is the head.
Yes, that is a picture of the head that was taken during my autopsy.
H2 picture, what does that describe?
Yeah, those are the abrasions on one of the arms.
H3 shows some what?
I think it's specifically meant to show the lacerations on the left upper arm and the lateral left chest.
Taken during your autopsy?
Yes.
And 4?
That's a picture of the back of the decedent, and you can actually see the laceration on the right upper back of the shoulder area.
Taken at your autopsy?
Yes.
Your Honor, I move for the admission of Exhibit H1 to 4, 1.1 to 4.
Your Honor, we don't have copies of these. I'm not really sure what he's admitting. I mean, I'm sure I have the copies of the autopsy, but I don't know what he's admitting. Is he admitting this as digital to the jury? Is he admitting these as copies to the jury? I'd like a copy of what he's admitting.
Your Honor, they were Dropboxed, my exhibits, 3 weeks ago.
What are you admitting to the jury?
The 4 pictures of the autopsy.
Are you making hard copies of them?
I have an extra set right here, but I Dropboxed them to them.
Okay, let's let the prosecutor see them.
If they're part of his Dropbox, I've seen them. I just didn't have them here to see which ones he's admitting. So
your plan is to provide a hard copy for the jury?
No, it's yes, as the jury exhibit. Yes.
Okay, so it sounds like he's laid the foundation. They're a very accurate representation of the autopsy photos.
Thank you.
Yes, they are some of the autopsy.
Counsel, are they at least? Yes, sir?
No, unfortunately it doesn't on this apple here, so I try to blow it up on the big screen.
Can I, Counsel, can you approach it to talk about the nature of the photos?
So apparently they're not done fighting. The spice level has been cranked up. The judge has reprimanded both sides and said, knock it off, dial back the drama. It's not working. The state is mad as all get out that their expert who was going to testify that she had a whole bunch of red towels covered in gasoline down she was trying to clean up in the basement, is not coming in right now, unless, barring some crazy case law they find, it's not coming in. That evidence, that report is not coming in. And insult to injury, the judge basically said it's your own dang fault, state.
To produce the photographs, I'll alert you now. You may find them disturbing. They're autopsy photographs, so the defense attorney, I've alerted to him to get him on and off the screen as quickly as possible to prove whatever he's trying to show you right now. But and then in the jury room, I'll make sure that they go inside an envelope so that you can choose to open the envelope or not when you're in that room to see them. Okay. So they are admitted. What are they? What?
H.1-4.
H.1-4 is admitted hard copy.
Thank you. I'm going to show you H.1 from your autopsy. Is that a photograph, sir, of the 2 lacerations to the top of the head that you saw?
Yes, that's a laceration of 2 of the 4, that's 2 of the 4 lacerations on his head.
Okay. And those didn't go below through the skull or anything?
They went through the full thickness of his scalp, essentially, pretty much down to bone. And 2 of them, the one on the left of that photograph, it had the indented small fracture underneath it. The other laceration that had the skull fracture underneath it was not visible in that photograph.
H.2. What does that depict?
I believe that's a picture of one of his arms, and it shows obviously that most of the skin surface is absent, and sort of the exposed skin is often red, and then there are some of those linear abrasions, scratches, scrapes there on his arm.
3. What does 3 depict for us, sir?
Yeah, this is a photograph that's depicting the lacerations there on his left upper arm, and the sort of abrasion with a smaller laceration there on the left side of his chest up there near his armpit.
And 4, sir, what does 4 show us?
This is a photograph of his back. Again, he's got diffuse burns, and then what you've highlighted there is the larger laceration that's on the back, his upper back, shoulder region.
Okay, thank you. So, as we went through all those injuries, in sum total, if you assume the van made those?
It very well he may have. I don't know exactly what made every single injury, but the constellation of those injuries, lacerations on several parts of the bodies and skin scrapes, could certainly be due to being struck, especially if you underneath the van and hit various objects that are on the undersurface of the van and on the ground.
Okay. I'm going to show you, before I publish it, I'm going to show you from Maciowski's Exhibit 8.1 to 3. Those again have been provided to counsel. They're your detective pictures.
Your Honor, and I mean this with all respect, I think the process is the issue here. Normally, when you admit exhibits, you admit hard copies for the witness and then publish to the jury. We just don't get them on an iPad. And the only concern being to ensure that these same exhibits that are being admitted here in court are the ones that are being provided to the jury. And I have no doubt Mr. Mueller would not do anything like that, but I just want to make sure that we're following the right procedure here with the admission of exhibits.
Your Honor,
going forward, I'll let you do what you will here, but going forward, I agree with Mr. Blair that it's a cleaner record if whatever it actually is that you're going to move to admit. If it's a hard copy, we do it as hard copy.
It will be admitted as a hard copy, but I could conditionally admit it with to link it up under Rule 104 with Detective Maciowski since they're his photos.
Well, I said I'll allow it this time, but going forward, further examination and exhibits, get us the hard copies, please.
Thank you. If I may have just approached the witness quick. Doctor, I'm going to show you about 3 photographs of the van that was involved in this incident. You see photos of the injury or the blood to the front bumper, or what's called the brush guard.
Yeah, I can see some red material. I can't tell what it is, but it could be blood. Yep, it looks like, again, similar material on the undercarriage.
Right.
Yep.
Okay. So we show Maciowski picture 004, that's the van.
Your Honor, I don't think we've admitted these under a proper foundation yet. They're being published to a jury. They haven't been admitted. These are not his photos. I'm not even sure what foundation we lay here.
Your Honor, under Rule 104, I'll link it up and you can conditionally admit the exhibit because it's their detective's exhibit.
Well, you shouldn't be showing it to the jury if it's not an admitted exhibit yet. So
it can be conditionally admitted, subject to linking it up.
It hasn't been admitted, Your Honor.
In any event,
Mr. Mueller, let me rule on this. I'll have you wait and admit it when you can lay a proper foundation.
I'll be happy to do it with Detective Maciowski. You've seen those photographs, sir?
I just now have, yes.
Those injuries that you saw to Mr. Stermer are consistent with having been run over and striking various undercarriage components, isn't it?
I mean, the injuries themselves, as I've stated before, very well it could be due to being struck and overrun and striking things on the undercarriage of a motor vehicle.
So the fact of the matter is any of these blunt force trauma injuries that we had that we listed were not life-threatening. They didn't kill Todd Stermer, did they?
That was not my opinion, no.
Van impact, all those blunt force trauma did not cause death, correct?
Yes, that was my opinion. My opinion was that he died as a result of the burns and the inhalation of products of combustion during the fire.
Your Honor, I guess I'm not understanding why we're writing everything from the doctor's report on a tablet. My fear is that we already have the exhibit from the doctor's report. Now writing it can be misconstrued. It's not an exhibit. I'm not really sure why we're rewriting the doctor's conclusions or statements on a tablet.
Your Honor, I can examine and summarize his opinion. He agrees with this. This is simply presenting his opinion in a summary form as we're going.
I grant the prosecution's request on this one. The witness can testify and the jury can hear his testimony. It doesn't need to be written down by the counsel.
Get your post-it notes out of here, she says.
Then let's talk about, sir.
Remove the tablet. Thank you.
Remove the tablet. Oh, you know that proffer chapped the state's hides, and they are going for everything right now. The gloves are off.
Second thing.
Pictionary
the
is
burn
over.
Injuries you talked about, you and I have talked before, right?
Yes.
And the burn injuries, you have told me, and you tell me if I'm summarizing this correctly, the burn injuries, you can't say, I know an accelerant was used based on these burn injuries, fair?
Yeah, that's out of my area of expertise to say exactly what type of burns they were. They're thermal burns. They may be flash or flame burns. I can't tell.
Okay. Third thing, let's talk about now the toxicology report. You discussed a little bit about the results of the urine test and the blood test, right?
Yes, I think we went through the toxicology results.
Okay, let me talk about that. I'm going to show you what we're marked, the toxicology report, which is part of the exhibit they showed you. And the urine specimen discussed hydrocodone, hydromorphone. Those are the metabolites, right?
Hydrocodone is a primary drug. Hydromorphone is a metabolite of hydrocodone that can also be administered as a drug on its own as well.
The blood test, let's talk about the effects of things in the blood test. See that?
Yes.
Okay. The only thing it had was caffeine, correct?
That is correct. The blood screen was only positive for caffeine.
And when you have tests that have screens in the blood, that's what you have is basically the active ingredient, right?
Well, when it's present in the blood, we know that it's circulating and it's likely having effects on the body. If it's only in the urine and it's no longer circulating, then it may not be having its intended effects on the body.
Okay. It's out. If we talk about it, it's in your system versus out of your system. You heard that before, right?
Yes.
He didn't have any of this hydrocodone or hydromorphone in his system, otherwise it would have been detected in the blood test. Fair?
As I stated previously, there were no detectable levels. That doesn't mean, as I stated previously, that it wasn't possibly there at a lower concentration than what the testing screen is able to detect. So a negative result is essentially it's not there in a concentration that the test can detect.
And the test can detect concentrations that would have an effect on the body, can't it?
Generally, yes, that it's set low enough that if it is present below that level, it would be considered, essentially not significant.
Okay. You also talked about Entex HC, right? Remember that this morning?
Yes.
That's cold medicine, prescription cold medicine.
I'm not familiar with exactly why it's used.
Okay. But it has hydrocodone in it, right?
Yes, it does.
And you said typically it's by liquid syrup.
I believe, yes, it is it's usually given in a liquid form.
Okay. So any of this hydrocodone, as far as your professional opinion, would not have been in a system to have any effect on Todd Stermer. Fair?
Right. There was none detectable in his blood, so therefore likely he was not experiencing the effects of hydrocodone at the time of his death.
So if somebody, witness or prosecutor, suggested that he had been drugged, that would be inconsistent with your objective evidence, wouldn't it?
It would be consistent with him being dosed hydrocodone sometime before he died.
In other words, therapeutic levels of hydrocodone, which would be just taking cough medicine, right?
There's no levels on there, so you can't say it's a therapeutic versus a non-therapeutic.
I think he was testifying as to the time distance between the two, not whether it was therapeutic or not.
I guess I'm not clear on the question.
You heard of the phrase therapeutic levels?
Yes.
All right, what does that mean to you?
They're generally levels that if you measure them are what you would expect to see or what's expected to be seen if the drug is in a concentration that is deemed to be effective from a clinical standpoint. So if you're talking about pain, what levels of medications cause or result in control of that pain, and that means in a sample, does the number that we're given for a certain drug fall within that range? Let's say the therapeutic range is 4 to 10. If a drug is present at a concentration of 6, then it would be considered to be within the therapeutic range and be in the range that is expected to exert its effect to treat whatever condition you're treating.
Bottom line, if he was taking cough syrup prescribed by his family doctor 2 days before, that cough syrup containing hydrocodone was out of his system by the time of this fire. Isn't that true?
He has no knowledge of what he took. If he wants to ask this as a hypothetical, that would be more proper than just testifying himself as to what the defendant did or did not do and then asking him to agree.
Your Honor, it is a hypothetical.
And there are no levels on the toxicology.
It is a hypothetical.
I'll ask you to rephrase it then, or state it again as a hypothetical.
Doctor, hypothetically, if Todd Stermer had taken cough medicine that was prescribed by his doctor 2 days before, Entex HC, for cold and ear infection, whatever effect that drug had was out of his system by the time of the fire.
Yes, in this hypothetical situation, if he took the drug 2 days before, it would be consistent with it not being detectable in his blood any longer, and he would not be experiencing the effects of that drug at the time of his death.
Or at any time before, because he didn't have it at detectable levels in his blood. Isn't that true?
Well, I'm not sure what you mean by at any time. I mean, if he had taken the drug 2 days before and 5 minutes later, he probably was experiencing the effects of the drug.
My question was poor. I'll try to rephrase it. If at the time of the fire he didn't have this hydrocodone in his system, you with me?
Yep.
Then no matter when he took it, whenever, it was out of his system.
Right, I think it's fair to say that, given the apparent brief time period between the fire and his death, that his concentration of those drugs would have been similar to what we see when he died, and probably was not under the effects of the drugs at that time.
Just going back to the idea of these lacerations on a blunt force trauma, you had 4 lacerations in 4 different places, right?
Are we speaking of just the head?
Yes.
Yes, there were four separate lacerations on his head.
So if there was a suggestion that maybe Todd Stermer got hit by a frying pan, that wouldn't be consistent with the injuries you saw, given that you know he had contact with the undercarriage of the vehicle. Isn't that true?
Well, again, that's, I guess, a multi part question. To answer your first question, I can't rule out that he wasn't struck with something based on just the lacerations. He wasn't struck one time with something, but clearly there are impacts to his head, and I can't tell you exactly what caused those impacts. Given the fact that it was reported to me that he was run over by a vehicle and there was evidence of body fluid on the undercarriage of the vehicle, it seems quite reasonable that that would be an explanation for the injuries that were seen on his head.
As you like to say, within a reasonable degree of medical certainty, it's more likely than not that all of those injuries to his head...
Objection, Your Honor, that's not what he said. It's mischaracterizing the evidence.
She can clean it up if she'd like.
No, I think I'll sustain that objection.
Your opinion is it's more likely than not, given the evidence you...
Same question, Your Honor. Objection for the same grounds.
I'll sustain the objection. I don't think he's given that as his opinion.
Do you have an opinion, whether it's more consistent, given the data you have, that he suffered those head lacerations from impact with the undercarriage of the vehicle?
I mean, I think I've answered the question that I don't know exactly what caused each of the lacerations. They are explainable by injuries sustained from the undercarriage of the vehicle. Can I exclude that there wasn't an injury from something else prior or in association with it? There's nothing specific about them that allows me to say definitively what caused them.
Based on the evidence you encountered and addressed in 2007, right?
My opinion is that based on my interpretation of the injuries, they are caused by blunt impact. They could be from the undercarriage of the vehicle, and they very well may be, but I can't say definitively what caused each separate injury.
Okay. Now, part of your process when you're doing forensic examinations, you're familiar with the scientific method?
Yes.
Scientific method is you collect all the data you can relevant to your topic, right?
Yes, as part of what I do, I collect data.
Okay, now listen to me and we'll see if we can work through this step by step. You collect data, right?
Yes, we've established that.
As much data as you can that might be relevant.
Yep.
Then you analyze that data, right?
I interpret the data.
Then you develop hypotheses, which are really just working theories of what it could be.
I mean, that's the scientific data. I do an examination, I interpret it based on my training and my experience, and come up with what I believe is the most accurate conclusion.
Okay. You test your theory against the evidence that you have, right?
Well, in my line of work, I try not to come up with a theory and then make the data fit my theories. I take the data and I interpret it based on my knowledge of pathology, forensic pathology, and the circumstances in which the death has occurred.
Okay. You understand the scientific method is to develop, when you test your theory, to try to disprove your theory, to rule out something.
Yeah, I understand that the scientific theory. I'm telling you what my protocol is in determining cause and manner of death.
And your protocol in determining cause and manner of death involves what you folks call in the medical field differential diagnosis, right?
Well, yeah, a differential diagnosis is when you take a finding and you come up with a list of possibilities that may explain that finding. For example, I don't treat patients, but if you come to the hospital with abdominal pain, they will take a history and they will say, well, we think your abdominal pain may be due to this, this series of potential diagnoses, and we will do further analysis to try to shorten that differential diagnosis, hopefully to a definitive diagnosis.
Right. So you're taking, it might be 3 or 4 things, and you're taking tests to try to rule out something, and ultimately you have a diagnosis. But you have to consider what it could be, right?
Right. I mean, when I look at an injury on the body, I have to evaluate an injury independently and determine whether it's a blunt force injury like a laceration or a stab wound or a gunshot wound or something else. That's part of what I do in not just saying there's an injury here, but then analyzing the injury based on my experience and my training to determine what that injury actually is.
Like a simple one. If this was suggested that Todd Stermer died of a gunshot wound, your examination of the body finds no gunshot wounds, right?
That is correct.
So you could rule out gunshot wound, correct?
That is correct.
That is part of how you do the differential diagnosis. And now we'll forget gunshot wound, we'll focus on something else, right?
Right.
Okay. So, in terms of his thermal injuries, these burns to the skin obviously would be painful, right?
Yes, I've never experienced burns like that, but I have burned myself and it hurts.
It hurts. And the pain is immediate, isn't it?
Yes.
Now let's talk about your manner of death and what you've considered. Am I right that when you're talking about manner of death, there are several different categories?
Yes, there are 5 categories in the state of Michigan that you can put on a death certificate for manner of death.
Would one be accidental?
Yes.
Would one be suicide?
Yes.
Would one be natural? You had a heart attack?
Yes.
Would one be homicide?
Yes.
And one would be undetermined?
Yes. And
if it's undetermined, the only one that supports a crime is homicide, correct?
I'm not sure that that is a correct statement. For death certification purposes, it's not for use in this setting. When I put something on a death certificate, it is for death certification purposes, for public health, for statistical purposes. For example, most automobile crashes we classify on the death certificate as accident. There's no intent generally to cause harm, and yet I've sat on a stand like this multiple times on cases where I've called a death an accident, but someone has been charged with a crime, say driving under the influence or reckless driving. So just because I call something an accident, or it's not legally binding in the sense of the judicial process. Likewise, just because I call something a homicide doesn't necessarily mean that from a legal sense a crime has been committed.
Sir?
Yes. I'm trying to answer your question, which is only one of them indicates a criminal activity.
Can you answer my question, yes or no, if you're able to?
Restate the question.
That's badgering the witness. He asked for an answer. The doctor gave him an answer. It was directly in response to his question.
She can follow.
He is badgering the witness.
That's hardly badgering the
I'll
witness.
sustain the objection.
Sir, you make these categorical classifications based on the evidence you have at the time, am I right?
Yes, based on the autopsy findings and the circumstances in which the death occurred, I provide an opinion as to what I believe is the manner of death.
Okay. And in this case, your manner of death was undetermined, isn't that fair?
That is correct. That's what is stated on my report.
If you had evidence at that time that it was a homicide, you would have listed it as a homicide, correct?
If I had had enough evidence that I felt independently comfortable that his death was due directly to someone else's intentional actions, then yes, I would have called it a homicide.
Okay. So let me just kind of summarize and make sure we're clear before I leave you. The van impact had no connection with the death. The death was caused by thermal burn injuries, fair?
Yes, I believe his death was caused by the thermal injuries.
You're not qualified, and you can't say that an accelerant, gasoline or anything else, had a connection to his burn injuries, fair?
Right. I don't do accelerant testing. That's out of the realm of what I do.
There were no drugs that were detected that were in his system at the time of his death, fair?
That is correct.
And finally, the manner of death is undetermined, fair?
That was my opinion at the time, yes.
Give me 1 second, Your Honor.
One more question here.
I know you're a busy man, Doctor. I don't have any other questions for you. Thanks.
Yep.
Thank you, Your Honor. Doctor, you don't need to know anything about the specifics of the van to do your report or your examination, do you?
No, not to actually do the autopsy. I mean, when asked questions to try to correlate injuries, then yes, it's sometimes useful to know, but to determine that those are blunt force injuries, I don't need to know any specifics about a vehicle.
It was enough information to know it was a van.
Yes.
And I just want to be clear on your findings. Those rib fractures could be from CPR, correct?
Definitely the two left-sided anterior rib fractures Very well, he could be from CPR. As I've stated before, the posterior rib fracture would be unlikely to be due to CPR.
But even the other ones could not be from CPR.
That is correct, too. I can't tell you that the ones on the left side in the front, I mean, they could be from something else. They're just, they could be explained by CPR.
Or they could be explained possibly by the van.
Yep.
And the injuries, the 4 separate lacerations on the head could be from the van.
Yes.
They could be from another blunt force trauma.
Right. If he had been struck with something else prior to being run over, then one or more of them could be from being struck. I can't say with absolute certainty that.
They could be from a frying pan.
Potentially.
It would be consistent with the injury, right?
Yeah, there's nothing specific about the injury that would allow me to say that he was or wasn't struck with something.
And I just want to be clear, you did the autopsy on January 8th. The fire was January 7th, so you're talking one day after, correct?
Yes.
And so you based your information and your report on the information you had the day after the fire?
Well, I mean, the final report wasn't issued until at some point later, so there probably was some more information that was obtained. But everything that all the information is summarized in my report as to what I had at the time that the report was issued.
And that's what you used then to come to your conclusions?
Yes.
And I just want to touch base, you talked about the pain that would be, that somebody would have from those burns. Would touching then also cause additional pain to the patient that's burned that badly?
I would assume so. You know, I'm not an expert on pain, but it would be painful.
Mr. Sprague asked him to speculate. He's not qualified.
He's a medical doctor.
Now he's talking about I would assume.
How long will that?
So, based on you saying that it would be painful for somebody to touch those burn injuries?
I would assume that the burns just of themselves would be painful. And I assume that touching them or moving him would have also been painful as well.
How about laying on him?
Again, you know.
Same objection, lack of foundation. He doesn't know what the situation was.
Outside of his area of expertise at this point, so I'll sustain.
I mean, okay.
One hand goes beyond my cross.
The rules of evidence allow that, but I'll sustain the objection.
I have no further questions, Your Honor. Thank you.
I told you it was going to be spicy after lunch. I didn't realize it would be.
As a medical professional, you deal in probabilities, not possibilities, don't you?
Well, I mean, my diagnoses are usually made on some degree of probability. Many things are possible. You know, I try to deal in what is most probable.
Because if you're dealing in possibilities, you're merely speculating, aren't you?
I mean, I guess to some extent, if it's possible, then I can't exclude it.
But it's guesswork to represent that it was something affirmatively to a jury, correct?
I mean, I don't think I've stated anything that I don't think is probable.
Not accusing you, doctor, but because you deal in probabilities to say it's possible it could be something and have a representation that it is that would be misleading, wouldn't it?
But I would never say that something is definitively this just because it's possible that it's that.
Okay. Have you had any autopsies where somebody was struck by a frying pan?
You know, I don't recall.
Yeah. If you get struck by a frying pan, typically it's right.
I'm going to replay
it. Your Honor, he's dealing with autopsies. He's certainly not there when somebody gets struck with a pan and how it affects them.
You can talk about the injuries. And
let's go on the highlights.
This is outside of his area.
It would typically result in a skull fracture, wouldn't it?
Probably that's an overstatement. It could result in a skull fracture.
Okay. Or not.
Or not.
Thank you. No more questions.
I have no further questions, Your Honor.
Jerry, do you have questions of him? Oh, yes. Oh, my gosh. Need more? Okay.
Okay. We're going to get this set up. Hang on. Give me just a minute. We're going to replay a couple things here. One thing specific. 131. With Y. So while they're thinking about that, let me just I'll keep the volume off here, but this is crazy. Boom, boom, boom. Here, I'm playing it too slowly. Look at this, the face he makes. It's absolutely nuts as he hits himself in the head. Whack. Then he reels. It's like he's a soccer player. Knocks himself off the picture. He just became a meme, I think. Let's see if I can play this at slow speed. Speed it up a bit. I'm sorry, that made my day. Need to add a cartoon sound effect. Yeah, let me. Let's see. Let's go ahead and play that in. The spiciness in court is absolutely wild. Dump that out. Okay. All right. Sorry, I'm doing some editing over here. Delete selected. Just going to export this part. I've got fire trucks coming here too, which is funny. Copy, new timeline. Zoom, there they go. Paste and quick export. All right, sorry, I was a bit distracted here. Oh my goodness. I'm gonna go season my cast iron skillet. This is wild. The reason they're so spicy is because the state lost a major battle at lunchtime. That their expert is not coming in. They're not going to be able to say that she was washing red towels in the basement that were soaked in gasoline. That was a huge, huge loss. And honestly, it's a massive win for the defense if they can keep that out. And that you've got to give them props for that.
I have some questions from the jury.
Stack them.
Do you know the performing laboratories' cutoff levels for their test validation or their established levels of detection and level of, some of you have really bad handwriting, level quantification for their drugs?
So the testing that was done at the time was done at a laboratory that no longer does the testing. I don't know any of the specific parameters for like the level of detection for any of the substances that they tested, nor any of the particulars regarding that. Having done this for a long time, they're generally relatively low, so I would expect that had there been something there in significant quantities, it would have been detected. But no, I can't give you, like for hydrocodone, their level of detection was 0.5 nanogram per milliliter. I don't know those parameters.
Similar question. Do all labs use, if you know, do all labs use the same detection levels for blood and urine?
No, they do not. Typically, the detection levels are quite different for blood and urine specimens. Urine specimens usually are significantly higher concentrations, the lower concentrations, just because the drug tends to accumulate in the urine. So they generally have higher detection levels in urine. Most labs don't quantitate or give you a level in the urine, but they generally will, at least in the forensic setting, in the blood. And those detection levels may vary from laboratory to laboratory.
You stated that 90% of the body was severely burned with skin intact at feet and part of a leg. I'm curious how a fingerprint can be taken when skin is burned off or sloughed off. Please further explain.
Yeah, he had burns to his hands. The skin actually was mostly sloughing off of the hands. So with burns, a lot of times the outer layers of the skin separate from the inner layers. And in this case, it wasn't present. You couldn't see it in the photographs, but there was still skin on the fingers. It basically was just sort of sloughed off, like if you were wearing a latex glove and you pulled it off. It was still there, but it really wasn't in place where it normally should be any longer on the hand. So in many cases, we are still able to get fingerprints in bodies that are burned, as long as the hands themselves aren't completely, the skin isn't completely burned off. In this case, the skin was more sloughed off of the hands than burned.
Okay. And there was one question, jury, that I'm not going to be asking. I've determined under the law not to ask it. Could lacerations be sustained from a fall or on stairs?
In this specific case or in general?
My guess is, how about both?
Okay. In general, yes, lacerations can occur anytime there's an impact. So if you fall downstairs and you strike your head on the wall, on a railing, on the floor, yes, you could get lacerations. I think, as I've stated before, I can't tell exactly what caused these lacerations. So, could one of the lacerations or more of the lacerations be from falling downstairs? I couldn't exclude that.
Thank you. If blunt injuries were possibly caused by the van, would the amount of blood on the van be there as soon as the body was impacted, in your professional opinion?
Typically, blood is transferred at the time of an injury. So, if you're struck by something and it causes a laceration of the skin, that generally you're going to bleed, and there will probably be blood on the impacting surface. So if you fall and hit your head on, the corner of a table, there's likely going to be blood on the corner of the table. There may be a lot more, on the ground after you fall and bleed. But yes, there would likely be blood on an impacting surface.
Thank you. Is there any testing of the surface of the skin to determine if there is anything, in parentheses, substance, on the skin? And also, did you receive any documentation in regards to Todd Stermer's pants or lack of pants?
I guess the question is, like, what sort of substance? Our laboratory testing of the body is usually body fluids, and they're usually being analyzed for medications, drugs, that sort of stuff. I can't test like the body surface, for example, for an accelerant. That's out of sort of my area of purview, if you will, when doing an autopsy. And what was the second part? Sorry.
Oh, it had to do with Todd Stermer. Here we go. Did you receive any documentation in regards to Todd Stermer's pants or lack of?
Not that I recall.
Okay. Counsel, any questions in light of those questions and answers?
No, Your Honor.
Mr. Mueller?
Yes, just a few. There was a question about if you fell down the stairs, could you get these lacerations? You had 4 different lacerations in 4 different spots on the head. You with me?
Yes.
That wouldn't be consistent with a fall down the stairs as compared to being under the undercarriage of a van, as you saw those pictures with the blood.
Well, again, you know, it all depends. I mean, if you fall down the stairs and, you know, you fall down 20 stairs and you hit stair number 4 on one side of your head and you hit stair number 12 on the top of your head as you're tumbling down, you may have more than one impact site. What we're talking about are, you know, lacerations that are very distinct from each other, are indicating, you know, different impacts. So anything in which you could potentially sustain multiple impacts could result in you having 4 lacerations on your head, whether that being falling down multiple stairs or being hit multiple times in the head with something, or being run over by a vehicle and hitting multiple parts of the undercarriage of a vehicle. There's nothing about them specifically that allows me to say I know what specifically caused them.
Okay. Something along the lines of 20 stairs, you said?
I have no idea. I'm just saying that you would have to have 4 impacts with something, either the stairs, the wall, you know, something.
Again, that's a possibility, correct?
Yes, just like the other scenarios I gave are possibilities.
Thank you.
Also a possibility it could have been a combination of all of those things. Is that correct?
Right. I can't say that they're not from more than one event or more than one object.
No further questions.
Jury, any more questions? Okay, we've got one more, it looks like.
Yay, more juror questions. Sorry, I'm doing some editing over here to get the frying pan clip the way I want it. This is just crazy. Lawyer knocks himself out in court. That's what's happening here. All right. One last question. These are great juror questions, by the way. Jurors are familiar with the reports, with investigations, possibly with prosecution or defense. We've got a lawyer. We've got a doctor. We have
question, but we'll try it again. Is it possible for a drug to be present but below the level of detection?
A scientist.
Yes. As I stated before, a negative result just means that the drug is below the level of detection. So if it's not there at all, then it would be negative and it wouldn't be reported. If it's at such a low concentration that it doesn't reach the minimum level of detection, then it would also be reported as negative in that instance.
Any questions from you two?
I do. Let me get this right. If it's below the level of detection, and you said they're low thresholds, right, for the blood?
Generally, yes.
Okay. Below the level of detection, it could be 0. There's nothing in there, right?
That is correct. It could mean that the drug just isn't there.
Or it could just simply be below that low threshold, that sensitive threshold to detect. Fair?
That is correct.
Either way, in this case, it was not in his system, correct?
There was nothing detectable other than caffeine in his system.
Thank you. I wouldn't want anybody to detect my caffeine level.
No, Your Honor, I have no questions.
Going once,
Going once, going twice. More questions. This is a test sensitivity question. Yes. Let's all test our caffeine levels. Mine is low right now. I've had nothing. There's one Mountain Dew in the fridge. I think it belongs to my son. I have not drank it. And it's been in there for 2 weeks. It's nice and chilled right now. I mean, it's ready. It's ready to be drunk. But that explains a lot, Center Beach. I know. I'm exhausted. It's that dang bird that keeps me up all night. Ah, the bird and the squirrels now.
Have a distinctive odor, and how would you describe it?
At the time I do the autopsy, it doesn't generally have much of an odor in most instances. In bodies that are severely burned, I mean like charred to the point where they look not even like human bodies anymore, then they do have a smell, and it smells, unfortunately, like something most of you have probably experienced, which is, you know, burnt flesh from animals, what we would call meat. So, unfortunately, you know, fortunately, he wasn't burned to that extent, but in more severe cases, it does have a smell of essentially burning meat or burning flesh.
Did you just say that people smell
Counsel,
like meat?
any questions in light of that? Ms. Ayden?
I just would ask, would your body fluids have more of a smell as you're burning? You talked about how the outer layer skin's coming off and the fluids are seeping out.
I mean, at autopsy, unless they're severely burned and charred, I don't usually notice like a distinctive smell just from a body that was burned, like in this case.
So by the time you get the body, you wouldn't even have any detection, even on a less severe burn?
Like I stated, on a severely burned, charred body, when we open the body bag, they generally smell like, you know, you've burnt something on your grill. If they're not to that point, then typically I've not recognized a distinctive odor.
Thank you. I have no further questions.
I'm sorry. He doesn't detect an odor at autopsy.
Questions, jury? Yep. Can I have a question?
Sorry.
That's okay.
Lots of questions. Here they come. One more is coming in. This is just piquing the jurors' curiosity. One after another, firing questions here. Wow, this was not a day to miss by any means. Holy cow, what a day in court. Trying to catch the question right as she starts reading it, because the juror's still writing it. It's a long question. It's a paragraph or two. When you say meat, are you talking like sirloin steak, ribeye, flank steak? What? You get used to smells. Yeah, he doesn't notice. I think that was the key word. He doesn't notice a distinct smell. I think any of us walk in not familiar with that environment in the autopsy, and it might turn our stomach. Is there another question? Because this one's no good. This one has a picture. It looks like someone's been playing Pictionary. Please, can we have our large Post-it notepad back? We were enjoying that. Alexis, I'm sorry. I'm sorry.
Objection from the jury, no objection from counsel. Can loss of blood contribute to detectable levels?
Generally not. As long as we have enough blood to submit, since it's a concentration and amount per the amount of blood that you have, it doesn't generally affect our ability to detect drugs. So, a normal human body probably has, a few liters of blood. What we submit for testing is generally, a few milliliters, and what they actually test is oftentimes even a smaller amount than that. So, generally, the drug is fairly uniformly distributed throughout your blood, and what I get is a concentration. So whether they analyze 4 milliliters of blood or 1 milliliter of blood, it should give the same relative concentration.
Okay. Any follow-up, counsel?
No, Your Honor.
None, Your Honor.
Any other questions, jury? No. May he be excused from his subpoena, counsel?
I would ask that he please be excused, Your Honor.
Thank you, Doctor.
Thank you, sir. Oh, wait, one more question.
Let the poor man go.
Exhibits, and I'll take care of this. Is that yours? Okay, thank you. Cytovine, did you want to take a break now, or?
That sounds great.
Okay, so jury, we'll take a 15-minute break before the next witness. Remember the rules. You can leave your binders in the chairs.
Jury's going to break, and they're like, did you see the guy hit himself in the head? Did you see that? The judge brought the jokes. This is crazy. Somebody on the jury is definitely educated in the medical profession. I think you're right. Hopefully they make the cut and are in the deliberation group, not the alternate group. They need to stop comparing autopsy to food. I agree. I don't think that's good for anybody, especially right after lunch. Odor-restrained autopsies can be lessened through refrigeration, odor-eliminating solutions, and basic tolerance. I think he has a lot of the basic tolerance category, probably more than the average person. Kind of surprised at the humor here. I suppose they need some mood lightening. It's been tense, Melly. It's been very tense with the fighting going back and forth between the two sides. There was a huge battle right at the beginning of the segment right after lunch. So basically, right after lunch, there was a motion argument before the judge. The jury was out, and basically the defense said, there's no way you can bring this expert in and talk about testing the red towels that were in the washer or dryer and say that they had gasoline on them because the original tests are gone. That original data from the tests are gone. It got thrown away. It's only kept for 10 years, and it's gone. So now you've got an expert in here who's done 10,000 of these tests, and he doesn't remember these red towels from any other red towels he might have done over the years, 18 years ago. You can't bring him in here and have him read his report and be like, yeah, I'm testifying, this is what it was. He has no recollection, and the underlying data is gone. And under Michigan rules, if you bring an expert, that underlying data has to be available. And the judge said, you're right. You're right. We can't allow it. Can't come in. The state has tried here to say, in that case, Judge, two things. First of all, will you prevent the defense from rubbing this in our faces at the closing arguments in front of the jury by saying, they told you they would tell you about some red towels soaked in gasoline. Did you hear anything about that? No, you didn't. Why? Because there's no evidence that was. They say, don't let them do that, Judge. That won't be fair because we already told them they're going to see these red towels soaked in gasoline. And now, with this last-minute filing, you kept our evidence out, and we can't do it. The judge is like, well, we'll cross that bridge when we get there. No ruling on that yet. But the other thing that the state says is, can we just bring in the report? I mean, forget the expert and all his testimony, what he's going to... Can we just bring in his report as a business record and get that in front of the jury and say, just look at it. Look at it. You can see from your eyes how it concludes that from this gas spectrometer, whatever it is, analysis of these red towels, it was gasoline. It was not kerosene. It was not lighter fluid. It was not, any other liquid flammable. It was gasoline. It was not kerosene. I said kerosene already. It was not diesel fuel. It was gasoline. that may not work either. So it might not come in at all, which means that that gets rid of one of those key pieces of evidence that she knew about gasoline in the house, and their towels have been used to clean something up maybe, or to spread it. Not sure. Let's see. She's going to get acquitted on an evidence loophole? Possibly. But if the state doesn't prove it, that's the right thing to do. The interesting thing here is if she is not found guilty in this trial, which, there's a lot of evidence that makes it look like she's pretty guilty. If she's not found guilty, the jury will walk out of here having some knowledge, and probably not very much, of a previous trial, and just know that they were here again. I think anyone who has some legal experience knows if there was a previous trial, that means there was a conviction, because you can't get tried for the same thing twice and not be there. But, barring some weird event, that doesn't happen. They walk out of here and they're like, wow, what a trial. What a trial. I wonder what happened at the first one. Oh, unanimously convicted, life without parole. She served 8 years of her sentence and then won an appeal because of prosecutorial misconduct and ineffective assistance of counsel. Wow, we came to a different conclusion. I wonder what the evidence was. Oh, it's different. But why don't they have the underlying data in the file? Dr. Bullwater, I don't know. This is frustrating. Why would they not have I can tell you it probably was not requested. Like the witness said, I've testified in 30 some odd trials, and only once did they want this data. We don't normally provide it. Most people don't want the ones and zeros. They want it to break it down for me. What does this mean? And so they didn't have it ready, and now they need it. Okay. How many made-up words do they have so far? 9. 9 made-up words. My current counter shows that we have man, I wrote it down and it auto-corrected to chronology. That was not it. The prosecutor used a word. She was supposed to say chromatography, and she said another word that was not chronology. I'll have to go back and find what it was. Does anyone remember? It was somewhere in between chromatography and chronology. I know it had a G in it. But spell check is fighting against my word list. We've got scintilica, ambulance, geographics, echoline, use, guesstimation, antihistamine, urine, and chronology, or I think it's chronology or something like that is what she said. Chromatology. Okay, I think that was right. Chromatology. Is that the right word? I think that's the right word still. She said chromatology. Chromatology isn't a word, right? Why is it? I think that is a word. It's just the wrong one. It's a study of colors. I thought it was something else. I thought I looked it up and it wasn't a word. Heard the defense say privity for privy and gentlemen's. I have to go back. Nomi, if you can find it, send me a timestamp. We'll add that to the list. It's the right, wrong word. It is possible they could think there was a mistrial. Guesstimation is, we're using Grok as the arbiter of all truth. Define guesstimation. Grok says guesstimation is a blend of guess and estimation, referring to the process of making an approximate judgment or calculation based on incomplete or limited information. Let's see. It's an informal word. It's a portmanteau of guess and estimation. It's recognized in casual usage to describe it. It's not always found in formal dictionaries like Merriam-Webster or Oxford or English Dictionary. It's probably one of the most official words in our unofficial word list. Gaily May, one more month and I'll be pink. Seems like yesterday I found RA. Thanks, y'all. Take care of yourselves. Thank you very much. Yes, there's mine. Mine don't count because I make up words all the time. You can't count that against me automatically. I thought Grok was a football player. We got used this morning. I think I've got the clip I want, but I need a tiny bit longer. Okay, here's our clip. I'm going to play this for everybody. Full screen, full size, regular speed. That's not it. That is not relevant. Okay, if you were just joining us, you missed this from earlier.
You get struck by a frying pan. Typically, it's right.
I don't know. I've never been struck by a frying pan.
I thought that was funny. All right, we got 3 hits in there just to make sure you caught that part. If Karen Reid is found guilty of killing John, then why can she be tried again when there's cases where they can't? Please explain why there's some cases where they can be tried again and where there's cases where they don't. Because in Karen Reid's case, the courts ruled that it was a mistrial, and a mistrial is a redo. Slow version, I can play it back slowly for you. About 80%. Does that work?
You get struck by a frying pan. Typically, it's right.
There you go. It's the first time I've seen that, so sweet Tats. He's going to have a headache. He's got a headache now. These two sides have been battling it out with each other fiercely, just fiercely. And ever since the state lost, they decided to push every issue they possibly can with the defense. And so they fought about the board, the Post-it note board where he's making notes in front of the jury, listing all the people who didn't smell the odor, doing the Pictionary, the drawings, and all that. And they got that thrown out because that's not entirely proper. They're fighting everything. They're like, he was answering the question. That is responsive. Don't make him say yes or no. It's fun. They're mad. You can tell they're still mad because now the state has got to scramble and think, how do we now address this issue? We have to solidify these different ways that we believe the defendant tried to kill her husband. And with this little piece of evidence with her with, towels covered in gasoline, it gets a little bit harder to convince that she might be involved in the fire. They are big mad. Was the demonstrative allowed by the court? No. The notepad was now taken out and removed from the courtroom. Can they test the towels now? I don't know if they still have them. You'd think they might be able to, but it might be too late. Getting those tested now and getting the stuff back in, it might be too late, past the deadline for trial for sure. New evidence. I think we might be coming back here in just a moment. Interns are working overtime this weekend. Towels were destroyed. I don't think the towels were. The readouts from the technical machine that analyzed the chemical properties of the towels, those readouts were destroyed. We need the tea on the jurors by our insider. I've got some tea, not a whole ton. We've got a lot of age stuff. We've got a couple jurors that are very, very active and involved in the questioning. Most of the questions have come from one or two jurors. So we've got some good stuff. Why can't they use the transcripts from the first trial? Because it was a mistrial, and you got to work from scratch. It's a start over. Laura says, "Can someone give me a too long didn't read? She did or didn't start the fire." Well, the state says she did, and defense says she didn't. Defense says some unknown reason caused the fire. Could have been Todd or, spontaneous combustion. The state says, no, it was her. She went to the gas station, bought a can of gas day before, or within 24 hours of this, within 24 hours of Todd finding out that she was having an affair, sent the kids off to the mall in another city to keep them out of the way, and then took care of business at home. We don't know yet if she set the fire. That evidence has not come in yet. But the last testimony, also helpful for defense. They basically testified that based on the results of the drugs being in his urine and not in his blood, it was basically out of his system as far as effects went. So he would not be suffering from those effects at the time of his death, which means he was not drugged at that time. Now, does that mean the state story is completely out? No, she could have drugged him in the morning when the kids were there, and she sent them off to another town. As he starts coming to, bring out the frying pan, whack. Okay, the drugs are out of his system, but now he's down for the count with the frying pan, and now since the drugs didn't work and the frying pan didn't work, let's get some gasoline and do that, and then douse the place with gasoline, light him on fire. And mission accomplished. Let's hop in the van to go pretend it was an accident. This is the state's story, basically. Then from there, as she's leaving, surprise, surprise, Todd comes running out of the house on fire, and she panics like that wasn't the way it was supposed to go, and she hits him with the van once, twice, runs him over. So that's what the state's trying to say. Can't quite understand how he got out of the house. It was magical, according to defense. I believe the sons are against her, and they may have some daughters that are on her side. Sort of similar to, I'll have to check and see. I'll have to look at the family tree. I haven't seen the family picture here, but I know there are two sons that are against her, and I may have some other family member that's on her side. That's really splitting the family up a lot, like the Melody Ferris trial. She has two daughters, not his. Okay, so that would make sense, Lily. I think the daughters are on her side and the sons are on his side. I think she has 3 boys. I thought they only had 2. Daughter is living with her now. Only her daughter believes she's innocent. When you live on a farm, you always need gas and diesel. I don't think her buying it proves anything. They have 2 sons and a nephew. They counted as a son. Basically adopted son. Is her new boyfriend the same man she had an affair with? I don't know. We know he's a significant other. How long has she been out? Stacy, the timeline goes like this. 2007 was the fire. She was arrested a few months later. 2008 is the trial. She's convicted by a jury, sentenced to life in prison without parole. She appeals. 2010 she was convicted. She appeals, and the appeal's granted in 2018, so 10 years later. 8 years later, excuse me. Math's really hard. 2018, and then she's been out on bond till now. So between 2018 and now, that's how long they took preparing this case for the second trial. So now we're back in court. Diane has a question. Did you tag me in it? There it is. It's curious to me why she was running around in jogging shorts and a T-shirt and no shoes if she actually did this. It's January. Wouldn't she be ready to make a quick escape? The neighbor who was cutting trees says it was short sleeve weather earlier in the day. It just got cold really fast. A storm front came in and it started raining, sleeting, and then snowing. It was probably just a warm spell in the middle of winter. Is the new boyfriend still alive? There is a significant other. I don't know what his status is right now, but he was in court during the lunch break. He was brought up and ordered by the judge to stop talking to witnesses because defense had been using him to talk to some of the witnesses, which is just, it blows my mind. So yeah. Did the autopsy show evidence of him being run over? The autopsy showed that he had injuries that could be consistent with being run over, and the van, had a blood on the front and underside of the vehicle that are consistent with running somebody over, and it was his blood. So I would say yes, that's been proven. Let's see, as I tried to tell you earlier, the witness that was held on bond was the woman that called 911. That guy's ex that was on the stand. Oh my goodness. And now she's in jail because she missed her subpoena. She missed her court date. That's the potential witness, that lady. The judge sent her out to get drug tested. Didn't like what she was seeing and said, I'm going to have you get tested at the jail. She asked her, is there anything in your system? She said no. And she went so far to say not even a little meth. I mean, that's pretty bold for a judge to be saying that. But the judges do see a lot of defendants, and she might see something in that defendant that didn't add up. And if she does have something in her system, that's not going to be good. Did she know she hit him or admit it or what? Depends on the story, Jennifer. At one point, she said she didn't see him. But at another point of the story, she says she saw him. She got in the van. She saw him run out of the house, and she ran to him and said, hey, lay down. Stay right here. Calm down. Don't hold still. And then she ran him over because she saw him, got him to lay down, and then got in the van and don't know how he got under the van as she ran him over, parked in the backyard. What was the witness name? Drug test? It was Calhoun or something? Jennifer, this is a wild case, and it's just getting crazier and crazier. I think the spice is not over. The state is big mad about getting some of their evidence thrown out, and it does really hurt their case. And defense is also big mad because they don't like the defendant being charged with anything. Her name was Connie. I thought there was a Calhoun or. Have we heard her explain why she was laying on top of him? I tried to think this through in what would make the most sense. Some sort of mourning, comforting, just total loss, devastation, throwing your arms around somebody. Oh no, I know what happened. and wanting to hug them. That's a possibility. But why she was putting her hands over his mouth when they were trying to do CPR, not sure. That doesn't sound good. What evidence got thrown out? The evidence about the red towels in the washer and dryer downstairs that were soaked in gasoline. The fact that they were soaked in gasoline got thrown out. He said it was a perfect day for cutting wood. 32 degrees in a flannel shirt is great weather for cutting wood, and not necessarily. He also said it was short sleeve weather. What was the reason that got thrown out about the towels? The reason, Laura, was the expert who ran the report, who did the testing of the towels, tested the towels, got the results, made a report, filed the report, and then waited to be subpoenaed. And when he was finally subpoenaed in 2024, he went back to he tried to call the company up to say, hey, I'm going to need a copy of those those tests that we did. The company doesn't exist, or it doesn't exist in the way it did before, and they only keep records for 10 years after the testing, and it's been thrown away. Looks like we're coming back here.
We're back on the record. People versus Linda Stermer. Jury's not here. Anything to address before we bring them in?
No, Your Honor.
I just have one point to make. They're going to be reading from Mr. Shinsky's interview with Linda Stermer from January 9 and 10. This document says it's a draft. So unless he can testify how accurate it is, who did it, I don't know, and they want to admit this as an exhibit in total. So
I don't know what you're talking about. Is this the next witness you're referring to?
It's a transcript of her interview. It's one of the things I indicated. Not only do we have hearsay, not only do we have relevance objections as to the whole transcript,
right,
but it's a draft. Who knows who did it?
Is that coming up next?
No, Amy Darling's coming up next.
She'll be short, and he'll be right after her.
Yes.
What is this, a transcript that's being read by someone?
Well, I have a transcript that was taken by Judicial as part of the fire investigation. It's all recorded, and so what he did is then he had it transcribed and then checked the transcript for accuracy against the recorded interview. So at the first trial, it was admitted in its entirety as an exhibit, the whole transcript of her interview, and we were intending to do the same.
So you're familiar with it? Here's what it is. Here's what it looks like.
The draft? Yes. So there's a concern about it being called draft?
It's a draft, and we don't know who did it. It's certainly not a court reporter.
Our fine fires doesn't say draft. It's the original exhibit from the trial.
You have the original?
This one here was marked as exhibit number 13 on January 6, 2010.
Well, I have one here that doesn't say draft, and he'll testify as to the accuracy.
Okay. So do you want her to provide you the one that doesn't say draft?
Yes.
Okay. I guess my staff can make copies to keep things moving.
Here, I've got it. You want to email it to you, or?
Have somebody run a copy and give it to me by the end of the day.
Yeah, I have an electronic copy on a flash drive I can send right now.
Okay.
If he wants a photo digital copy, a hard copy, I can have some print off downstairs.
Mr. Mueller, did you want a piece? I heard you say end of the day, but I couldn't hear what you said otherwise.
I want a hard copy today.
By the end of the day.
Just give us a few minutes, we'll hand it to him.
Okay. Anything else on that matter before I bring in the jury?
No, Your Honor.
Okay. Bring in the jury.
All right, waiting for the jury. They're a little obnoxious. They're not playing well together. Both the state and the prosecution are angry. would like to cover Sheriff Stein's trial, although he's now saying he's pleading insanity, which is starting to make more sense. I'm pretty sure there's going to be some secrets coming out during that trial. That whole case is just wild. I haven't been covering that one, Jennifer. We've been here instead.
Ms. Ayden, you may call your next witness.
Thank you, Your Honor. Please call Amy Darling to the stand, please.
Amy Darling?
And before you have a seat, I'll have you pause and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? Yes. Thank you. Please have a seat. And when you're settled, we'll have you give us your full name and spell the last, please.
My name is Amy Elizabeth Darling, D-A-R-L-I-N-G.
If you can move that microphone up a little bit closer so the jury can hear you. Thank you. Ms. Ayden.
Thank you, Your Honor. Ms. Darling, what is your current occupation?
My current occupation is Drug Demand Program Manager.
And how long have you been in that position?
I have been almost 3.5 years.
And what did you do prior?
Prior to that, I was a 911 dispatcher for Michigan State Police.
How long did you do that?
Almost 18 years.
18 years. And at any point were you then also the medical examiner?
I was.
What years were you the medical examiner?
From 2000 until 2000, my apologies, 2022.
So you do that in conjunction with your other occupations?
I did.
And can you explain to the jury what a medical examiner is?
Medical examiner investigator is a person who goes out and any unattended death in the county that I resided in, which was Van Buren County, is investigated. Findings are then taken to a medical examiner or to their primary doctor to determine cause of death.
So you assist on scene, is that correct?
Yes, ma'am.
And you're called out on all deaths?
Any unattended death, correct.
What's unattended death mean?
Unattended death is any unwitnessed death by a physician.
4:30.
So, for example, if a physician has somebody with a heart attack in the hospital, you don't have to go there.
Correct.
This would be just anything out in the community that a law enforcement person would call you and say that a doctor didn't witness this.
Law enforcement, emergency services, or ambulance services, first responders.
Okay. Perfect. And as part of your position as a medical examiner investigator, were you called out to the scene on January 7th of 2007 to the Todd Stermer home?
I was.
Do you recall approximately what time of day you went out there?
Approximately 16:30.
So 16:30 in military time.
My apologies, this is 4:30 p.m.
4:30 p.m. Perfect. And do you remember what you did when you first arrived?
I did.
And what did you do?
I went up, I made contact with the law enforcement that was on scene and the EMS personnel that was still on scene with the decedent.
And did you drive down the driveway?
That I do not recall.
So once you got to the residence, you made contact with who?
The law enforcement and the ambulance personnel that was on scene.
And do you recall approximately how many people were on scene at that time?
No, ma'am, I do not.
Was it chaotic, or were a small number of people?
It was pretty chaotic. Law enforcement was there, fire department was still there, emergency medical services were still on scene.
So all of the ambulance, fire department, police, everybody was still there?
Yes, ma'am.
Okay. And what did you do then when you arrived?
I took custody of the body from the ambulance personnel and received reports from them about their attempts to resuscitate Mr. Stermer.
So you spent time talking to people on scene about the attempts?
Correct.
And what attempts were you aware of at that time?
The ambulance scene performed advanced cardiac life support, which involved trying to establish an airway, trying to restart his heart, both by electric mechanisms and by performing cardiopulmonary resuscitation.
So once you were advised then of all of these attempts, then what was your next action?
My next action was to examine the body.
And where was the body?
I'm sorry, sir?
What the body?
Examine the body.
And where was the body when you had the opportunity to examine it?
The body was out on the ground, away from the house a little ways.
So still on location on the ground?
On location on the ground.
And what did you observe when you examined the body?
First observation, it was that there was a figure underneath blankets. Blankets were removed to find a couple jackets that were laid over the decedent. Those were removed. Find a white male that is sustained burns all over his body to the point where his skin was sloughing off and his fingers were degloving. There were signs of medical resuscitation efforts, including defibrillator patches. There were burn singe marks all over his body that were still contained skin slippage, which means that the skin was falling off of the body itself. The male had burnt, singed skin up around his face. His hair was down to stubs, both around the facial area and throughout his head, where normal hair growth would then. It was unknown if that was his haircut or if it was from the burning. The decedent also had dirt that was on his knees and shins that was caked into the grooves in his knees. He was found to have a laceration on the back of his head that was open and substantial burns on the left shoulder with an open laceration on his bicep area.
Was there any bleeding at that time?
Yes, ma'am. It was prevalent of the seepage. It's not necessarily bleeding when they're deceased at that time.
So, okay, so you had seen the seepage. Was there blood present on the scene with the body?
The body had been moved prior to my arrival. The first responders, after I did my examination and readied the body for transport and secured it, talked to the investigators that were first on the scene and our resuscitation efforts. They actually moved the body away from the burning structure prior and relocated it. So there was no pooling of blood or bodily fluids at the location where the decedent was found.
And at that time that you arrived, was there any heartbeat?
No, ma'am.
Any pulse?
No, ma'am.
And did you pronounce him dead on that scene?
I did not. The paramedics that were on scene called Lakeview Hospital, and they established the time of death as 16:17.
And once that time of death was established, what's your role?
My protocol is that I'm called out after that is determined.
I apologize. So that actually happens first?
Yes, ma'am.
And so after you've had the opportunity then to examine the body, what's the next steps that you take?
Then I talk to the personnel on scene, trying to get as much information about how the body came to be in its location, information about it, who the responders were on scene that I could ascertain. Then the body is then secured in a body bag, and at this time the medical examiner had determined that it definitely needed to go for an autopsy. So the body bag was secured in that fashion. The zippers were tied, and it was sent with Calvin Funeral Home to Sparrow for autopsy.
So you say that the body bag was secured and tied. Can you explain to the jury what that means?
Secured and tied means instead of placing a security device on one zipper where it would contain the name and possibly, if we had at the time, the case number for the decedent, the zippers are actually put together and tied together. And then the decedent's identification information is added onto that.
Does that have to be clipped with a tool then to be able to be opened?
It has to be clipped in order to move the zippers.
So not something that somebody could readily just open?
Correct.
And there'd be evidence then if somebody were to break into that?
Correct, because the name tag would not stay attached to that zipper that way, the way that it's secured.
Did you also take photos then of the body?
I did not.
You did not. Do you know who did?
I believe the sheriff's department, but I'm not for sure.
Were you present when they were taking the photos?
No, ma'am, I was not.
Okay. And you mentioned that there were several articles of like clothing laid on the decedent?
Yes, ma'am.
And what is done with those items?
So the articles that were covering the decedent's, most of his body, the jackets and blankets were set aside. The decedent had socks, underwear, and sweatpants that were on. The underwear and sweatpants were collected by the fire marshal who was on scene because they had the odor of accelerants on them.
And then what happened with the other items?
The other items are left there for the police officers to either take with or they're discarded.
Do you recall what items then went in the body bag then with the body?
The pair of socks is the only article of clothing that went with them.
Was there any of the items that were thrown on the body that would have gone in that body bag?
Not to my knowledge.
Okay. If somebody were to have put one of those items in, a shirt, would you have known about it?
I would have seen it.
And you did not see a shirt?
I did not recall seeing a shirt.
Okay.
Oops.
And you said that a few of the items then were taken and released to then, who?
The fire marshal.
The fire marshal.
Michigan State Police Fire Marshal.
And do you know who that was?
That was Sergeant Leroy.
And then did you do anything else on scene?
No, ma'am.
So once the body's taken away, then did you just leave?
Correct.
Okay. I have no further questions, Your Honor. Thank you.
Should be a quick witness.
Doctor, I'll start out with a simple question. You don't know what caused the fire in this case, correct?
No, and I'm not a doctor, sir.
I thought you said you were...
A medical examiner investigator.
My fault.
Nope,
Sorry.
that's okay.
Okay. You don't know
Congratulations on the
what
promotion.
caused the fire or where it started, correct?
Correct.
Okay. Let me back up a little bit. When you come out, do you have a notepad or a binder where you're checking off stuff? How do you keep track of what's on a body at a crime scene?
What's on a body at a crime scene?
Like we had clothes here, you're responsible for making sure things get to the medical examiner's office for an autopsy, right?
Correct.
Okay. How do you document what's on there so you know?
I write a report.
And you wrote a report in this case?
I did.
In this particular case, you said Sergeant Leroy took the sweatpants and the underwear from the scene, correct?
He took them from the decedent as evidence.
Did you see him do that?
Yes, I did.
Did you, obviously you authorized him to do that?
That is part of the investigation, correct.
What if that's considered evidence? It might be a possible crime, right? You understand that?
Correct.
All right. Why is Sergeant Leroy taking evidence from a possible crime scene without the body first going to the medical examiner's office to determine what relevance it might have?
Sir, that would be something for the fire marshal. I don't know their protocol. It's between them and the detective bureau.
Okay. Am I clear? And you worked for Van Buren County?
I worked for Van Buren County Medical Examiner's Office.
At that time?
Correct.
Did the Van Buren County Medical Examiner's Office have any kind of a policy, written policy regarding allowing evidence, clothing, whatnot, to go from a crime scene without being okayed, or strike that, without being transferred to the medical examiner's office who's going to do the autopsy?
When it is deemed that it's part of the protocol that if it is law enforcement and they are taking it as evidence, not to just take it and discard it, they are in charge of that.
Okay. That is a written policy by the Van Buren County Medical Examiner's Office?
Sir, I don't have access to that. I couldn't give you the exact, that is how it was functioning.
Okay. That was the custom, is what you're telling us.
Sir, I cannot say for sure if it is in a written policy.
Okay. Or a formal procedure, it's just that's the way it was done?
That was the way it was done.
Okay. In this particular case, you need to make sure there is a chain of custody, am I right?
Correct.
So you document in your report what was taken with the body bag and to the medical examiner's office.
Correct.
Did you say there was a funeral home? It goes to the funeral home first?
It's transported by a funeral home. I don't have the ability to transfer a body in my personal car.
Okay. So a funeral home gets contacted, hearse or something?
Correct.
All right, then they take it to the medical examiner's office for an autopsy.
Correct.
I don't put the bodies in my own car.
Anything else that you remember that Sergeant Leroy took?
No, sir.
How many, this is 18 years ago, how many scenes have you been to in the course of your career?
Sir, I couldn't tell you.
Countless, right? And yet you remember the odor of an accelerant on this particular body 18 years ago. Is that right?
Correct.
And in your report, you must have, that would have been important, right?
Mm-hmm.
Yes?
Correct.
Did you write that down in your report?
I did, sir.
Can I see that? Do you have it in front of you?
Well, he challenged her on it.
Would you like me to show you where, sir? So you don't have to search around?
I'll take it, thank you.
She's like, yeah, I've got it in my report.
And once the fire marshal was present, you were letting him take over in terms of whatever, and this would be Sergeant Leroy, thought was relevant. Fair?
Negative, sir.
Okay.
I'm in charge of preserving evidence on the body. If he had something that was on the body, or one of the detective bureau had something on the body that was deemed as evidence, they could secure that. They weren't allowed to take a sampling of vitreous humor, the fluid from the eye, or blood, or anything that pertains to changing the composition of the body.
Of the body itself?
Correct.
Okay, so in your report, one of the things you learned, you try to get the background of what was going on, right?
Correct.
And you learned that Todd Stermer, where you found him, wasn't where he originally was when the first people who came on the scene got there, right?
Correct. That's in my report.
And in your report you said, after they moved him, they found him in cardiac arrest. They removed him from the boat and started CPR. So you learned at some point in time that there was a boat involved. Is that correct?
Correct.
Okay. Nobody told you a little 3-foot sled or anything, right?
Negative, sir.
Give this back to you. Was the end of your involvement when the body was transported?
Correct.
So you only had a short period of involvement, is that right?
Correct.
Okay. You took no photos, correct? You did write that report, right?
Correct.
Okay. Would you agree with me that chain of custody is very important in your business?
It is.
Why?
Because it is a legally defensible chain of evidence.
And that's why you have procedures.
Correct.
To protect that chain of custody.
Correct.
Including the underwear in this case.
Correct. I wouldn't have handed it off to a firefighter. I handed it off to a law enforcement official.
Okay. Are you aware, and you're certain about your memory, right? You seem to have a good memory about it, even though it's 18 years ago. Yes?
Correct.
Are you aware that Dr. Markey testified that the underwear and socks were in the body bag?
I was not. I'm going off of what I had documented down.
Okay. If Dr. Markey testified to that, you may possibly be incorrect. Isn't that right?
Correct. I'm going off of my report. As you said, it was 18 years ago.
Working for the county medical examiner's office, you have testified countless times on the side of the prosecution in cases just like this, right?
No.
Have you testified ever in a case like this for the prosecution?
I have testified one prior time.
In your whole career?
Correct.
Okay. And that was for whom?
For Van Buren County.
For the prosecutor's office?
Correct.
And before you came here today to prepare for today's testimony, I imagine you met with the prosecutors?
for about 5 minutes on recess while she was filling her water.
Give me 1 second, Your Honor.
He did not get what he wanted out of this witness. He tried to do this is what's important. You would have written down in your report, right? That detail that you could smell accelerant, or that was a boat or whatever it was. She's like, yep, it was, and I did. You want me to show you where it is? He glanced right over that. Nomi, I didn't see your timestamps right here. Made up words, part 1.
You were an investigator. You were not the head of the medical examiner's office, am I right?
Correct.
Okay. So when you get to the scene, you're talking to the law enforcement people just to get your arms around what happened.
Correct.
And that's how you got that background about the boat.
Correct.
Okay. Who determines what evidence is going to be taken with you or under your, I'm going to say, jurisdiction versus a fire marshal deciding what he thinks he needs?
That's dependent on the situation.
Let me just drop something. Would it typically be if a law enforcement officer thought that there might be a crime, he or she has the discretion to take what they want?
I do not have training in law enforcement. I don't have any say as to what I can or cannot do to assist or impede in their investigation. Mine is the body.
Yours is the body, but you agree with me that evidence on the body, including clothing, maybe jewelry or whatever, could be important evidence, fair?
Correct.
Right. But you don't have that discretion to tell the law enforcement person, this goes to the autopsy?
We could discuss it, but that was not my call. My expertise is not fire marshal. I have no idea or reasoning behind why he would need those clothing or tell him how to do his job.
Okay. And you are not aware if there is in fact a written policy regarding authority to take evidence off a body?
Your Honor, that's been asked and answered.
Just real quick, you were doing this for 13 years.
Correct.
All right. You've done countless scene examinations just like this, right?
Not just like this, no.
Where you come out to a scene and examine a body.
Yes, sir.
Okay. And you're not aware of what the policy is.
Your Honor,
That's not asked and answered. You know, you get to one last question. And you're not aware of the policy, fair?
I do not have a written policy that was in place.
Well, there was no written policy.
I do not have it. I do not have what they have. I've not been in this field in many years.
Yeah. But you had it back then.
The standard of practice was to let law enforcement do their investigation. Mine was the investigation for the body and the reporting to the medical examiner.
Thank you.
You're welcome.
Thank you, Your Honor. So I want to just kind of talk to you a little bit about that chain of custody. So when you seal that body bag and you secure the zippers with the tag, and it goes to then the autopsy, it's secured, correct?
Correct.
So if Dr. Markey, who did the autopsy, opens up the body bag and documents what's in the body bag, do you have any reason to doubt that that's incorrect?
No, I do not.
And so that would be documented in the pathology report to the best of your knowledge, correct?
Correct.
Okay, no further questions, Your Honor.
No reason to disagree if Dr. Markey said the underwear was in the body bag, contrary to your report.
Sir, I can only attest to what I have as documentation.
Okay. Question is, you have no reason to disagree with it, I think you said.
If Dr. Markey has that documented, that's what shows in his documentation.
Thank you.
No further questions, Your Honor.
Jury, any questions of her? No? Okay. Thank you, ma'am. Is she excused from her subpoena?
I would ask that she please be excused from her subpoena, Your Honor.
Thank you. Thank you. You're all done.
Wow. Wow. Fiery, spicy. It's getting good. We've got about
Stand, please.
About half an hour. This should be our last witness.
Thank you very much.
That buzz isn't annoying at all, is it?
Good afternoon, sir. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? Thank you. Please have a seat. The chair is pretty clunky.
A little more leg to fit.
Okay. And then you can move the microphone towards your mouth and let us know your full name. Spell the last, please.
Name is James Shinsky. The last name spelling Shinsky.
Thank you. Ms. Ayden.
Thank you, Your Honor. Mr. Shinsky, what is your current occupation?
I am technically retired from the Raymond Corporate Investigative Services as a fire investigator. However, I'm still on their part-time payroll as needed to finish the cases that I left behind.
And how long have you been in that role?
A fire investigator.
Fire investigator.
I started my training in investigation on my first fire as a trooper in 1982.
And then when did you start then? So you were a trooper for how many years?
I retired from the state police in 2003. I was a full-time fire investigator for 8.5 years, 6.5 years running the training and certification in schools that the state police puts on for other agencies. Retired in June of 03, and then went to work for the Raymond Group in August of 03, and I'm still there.
And what did you do then with the Raymond Group?
Full-time fire investigator.
Okay. And so who would hire you as a fire investigator?
A lot of work, insurance companies, law firms. Sometimes we'll get, corporate jobs, product liability stuff, they need a fire investigator.
And as a role as a fire investigator, did you become involved in a fire at the Stermer residence in January 7th of 2007?
Yes.
And what was then your role with that particular fire?
Determine the origin and cause of the fire.
And were you then to interview, did you conduct interviews?
Initial preliminary interviews, general information about the site, the events of the day, do the origin and cause investigation, and at that point, depending on your findings, would be the end of my role as the origin and cause investigator.
And as part of your investigation, did you have the opportunity then to interview Linda Stermer?
Yes.
And do you recall when that interview happened?
I believe January 9th and 10th.
2 days?
2 days.
And why was it 2 days?
We started to do the interview on the 9th. She had appointments. Was supposed to meet with the funeral home and other appointments. So we ended that day and then scheduled on the next day to finish the interview.
So it was kind of just a continuation?
Yes.
And you had contacted Linda then obviously to arrange these interviews?
Yes.
And where did they take place?
The first one was in my work vehicle on the property, and then the second day I believe we sat in her car, or it was a vehicle there. We basically in the vehicle and did the interviews.
And you say driveway of where?
In front of the home.
And did you request that to meet?
The lost location.
Okay, so you wanted to meet her at that location?
Yes.
Did you have any sort of information that from the police officers at that time?
Just the initial investigative stuff, what they had. I believe fire chief was there, talked about their response, the fire call, their suppression activities, pretty much the standard, upfront information to get started.
Was it typical then for you to do interviews in your car?
Yes.
Kind of a common practice?
That was the rolling office.
Were these interviews recorded?
Yes.
And after you recorded them, at some point were they transcribed?
Yes, in our home office.
So who did the transcription? Your home office?
Yeah, it would have been one of our secretaries in the investigative group.
So once they're transcribed, they're reduced to then a written transcript?
Yes.
And then did you check the transcripts against the recording for accuracy?
Yes, always.
That was your common practice?
Yes.
And you did that in this case?
I did.
Pardon me?
I said, your question was who did that?
Oh, I'm sorry. You did that?
Yes.
Okay. And they were accurate compared to the recording?
Yes.
I'm going to show you what's been marked as People's Proposed Exhibit number 6. If you could just kind of leaf through that and tell me if you recognize it.
Yeah, that's a copy of the transcript on our interviews.
And can you just leaf through to the back and make sure that there's no alterations or changes?
Yeah, it looks like a full copy.
Your Honor, at this time I'd move to admit People's Exhibit number 6 into evidence.
Object, Your Honor. On the grounds that I don't know what she intends to do with bits and parts of the transcript, but to admit the whole transcript has hearsay in it, has a bunch of irrelevant information in it. So if she wants to read question and answer, we can go ahead and I'll make my objections, but not to admit this transcript in total. We're going to go through as she reads it. That was part of my objections to the exhibits.
Do you have specific sections we could talk about?
Yes, Your Honor.
Looks like the jury might get to leave here real quick. That's the judge's microphone that's buzzing like that when she's talking.
Does someone have an extra copy for me by chance?
Would you like an electronic copy, Your Honor? Just real quick, or a hard copy?
We could do electronic copy.
Okay, thank you.
I'll email it to the court right now.
I don't know. Do we approach?
Yeah.
Okay, so the judge is not accepting the objection from the defense here, saying they don't want this report coming in. This report has all the interview transcription. We don't have the recording, apparently, but we've got the transcription. It's been verified. This guy's laid the foundation saying, I did the interview, I recorded the interview was transcribed, and then listened to the interview, followed along with the transcription. It was all done correctly, and this is right. That's pretty solid. That's good. The objection was hearsay and a bunch of relevant stuff. The judge says, be more specific. He's like, well, how about you just go line by line and we'll fight out each one? And she's like, no, let's fight it out right now. Which ones do you object to? It seems like the judge is leaning towards allowing this in more in its totality with possibly some redacted parts. But she also wants a copy to see exactly what's going on. Sidebar not quite over. They went back. Ooh. He wants to make speaking objections throughout to interrupt the flow. I'm sure he does. This courtroom looks big. It's deceptively small. It's a small courtroom. Beautiful. I mean, the amount of woodwork in here is incredible. It's extremely ornate. Fun fact, this, thanks to our court watcher, by the way, this courthouse has a large mural over the stairs of a topless lady, which just like, and we have that. I don't know. It's probably some like Greek or some reference because she's like reclining on the head of a statue or something. So I would show you the picture, but we can't do that here. So you have to Google it. If you go to Google, you can see the artwork. It's a unique style. Let's put it that way. It matches the ornate woodwork with the design, and the paintings are just sort of wild. They're out there. It's not Lady Justice, I can tell you that much. It's not this fine specimen. It's not it.
Okay, Jerry, the matter we have to address may take a while, so I'm just going to let you go home for the long weekend. And because it's a long weekend, I'm going to just remind you, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction, as well as all of my other instructions, such as not discussing the case with anyone, including family or friends or each other, no research investigations, and enjoy your 3-day weekend. Remember, you don't have to come back until Tuesday, directly to the jury room at 9 o'clock, and wear your badges and try not to lose them over the 3-day weekend. Thank you. And you can leave your binders in your chairs.
All right, so Monday is National Crayon Day. Apparently that's a holiday in Michigan. Holiday on Monday, National Crayon Day. Who knew? It's not just that. It's also Eiffel Tower Day, which I don't think Michigan's big on celebrating, and World Backup Day, which I'm a big fan of as a digital guy myself. Is there something else? Oh, and Cesar Chavez Day as well. That's probably the big one, but Crayon Day as well. So I'm not sure how you plan on celebrating, but it should involve something from Crayola at some point. I can't say the word color, so I guess I can't celebrate National Crayon Day.
Any matters to address, other than what we talked about? You two will make a preliminary. You'll make a preliminary staff. Yeah, in the conference room, wherever. Okay, yeah, because how about or down in Susan's office? Yeah, if you could at least pick out the areas where if you still agree to disagree, I'll rule on those.
As long as we agree, then we'll black them out, and then if you don't agree, we can just bring them to you. If you want us to send them to you prior, so that you can have them.
Yes, that would be great. Thank you. Yep, and with maybe a note of where you're, how far apart you are.
Yes and no.
Yeah, or if there's if there's 3 areas of concern, that's one thing. That I have to rule on. If there's 30, just so I can prepare. And then there was this. I thought I toyed with the notion of having that the lay witness come in to testify now, but in light of her test results, I thought.
I think that was we all expected. I don't think that was unexpected results.
Welcome to West Michigan.
I thought what we can do, Your Honor, is I'm going to be switching around some of the witnesses who weren't able to testify that we sent home, shift around some things on April 1st. Maybe we could put Ms. Medina or Connie Calhoun on that day on the 1st. And then we have to move Scott Leroy to the 2nd.
Can we do me a favor? Over the weekend, you just email us our list.
The updated list. Yes. Yep.
Thank you.
No problem.
And Jay, would you mind just emailing us a copy of that hard copy?
No, yeah, no problem.
Thanks.
Actually, I'll just report for bid. Yeah. I'll just forward you. I forward it to the judge. Okay. It has it already attached.
Yes. So what we can do is we can redact what we agree on, and then any parts that we don't agree on, why don't I highlight with the yellow highlighter, and then that way the court can then just hone in on the highlighted portions. Yeah. And then otherwise, if we agree, we can go ahead and black it out.
Well, if you want to include your assistant on this, or
We'll get involved.
got it. My email address. I have your Mr. Kelly. Yes, sir. Yep.
right. It's just noisy as everyone's leaving. That courtroom is terrible for sound. The lay witness tested positive. Surprise, surprise, to nobody. So she can't testify today. Maybe after she sobers up over the weekend in the clink, she can testify on Tuesday. It's a long weekend, so Tuesday she'll be back out, and then she can testify then. Then it'll be a little more trustworthy. If you testify under the influence, that could be a problem. So the judge was right. She used her little sniffer and said, I smell something's wrong. Something stinks in Denmark here. And that's a bad reference. But yeah, she's in trouble. She's in trouble. Oh, my goodness. What a day. Just a quick recap of some of the things that happened today. Our Pictionary board got thrown out of court today. We had a huge fight that the state lost involving an expert witness and testimony about gasoline on the towels that were in the washer and dryer. We've had fights over all sorts of little things that were a big fight in court. So much the judge had to tell both sides, look, knock off with the drama. Dial it back. They did for a minute, but it came back. They are at loggerheads. It's crazy. We got the boink. We got the boink that happens. Not the bonk. It was a boink. And we can play that. This is a fun little thing that happened today. This is in. There we go. This was in questioning the one of the witnesses. The witness that was before and after lunch was asked this question about being hit in the head with a frying pan and what happens, because apparently examiners know this. Medical examiners know this.
You get struck by a frying pan. Typically, it's right.
He says, I don't know. I've never been struck in the head by a frying pan. And of course, there was an objection, but the fun part is the
frying pan. Typically, it's.
So we can turn the sound off and go back and forth. Look at his face. This is so good. First of all, he pushes himself off the screen. Whack. Looks like he sort of deflected it on his head. Hit the back first, then sort of rolled to the front. Bonk, bonk, bonk. Anyway, that happened. That was fun. Who claims he was hit by a frying pan and supposedly how did it? The state thinks that one of the injuries to Todd, one of the 4 injuries on his head. Now remember, he had 4 distinct directional impacts on his skull. Okay, he got run over by the van, but there were 4 areas where there were lacerations or dents in his skull. One on the top, one on the back, one on the right side, one on the left side. I did that backwards. Right and left were backwards, but the rest of them were right. The state is saying one of those we think happened in the house. You've got he was drugged, and then maybe as that wore off, the frying pan came in and said, "Hey, let's let him sleep a little bit longer." Bonk, bonk, and then as that was wearing off, it was let's do the gasoline, and then when the gasoline didn't work, it was resorted to the van. So it was like a four-parter. Lay witness was drunk. I think it was drugs. I think the judge suspected meth was her guess. So I think she might have been accurate. Who tested positive for meth? I believe the lady who called 911, the lay witness. The problem is she was in front of the judge right before lunch because she missed her court date. She was subpoenaed to testify in court and didn't show up. And she would be one of the earliest witnesses because she's one of the ones who called 911. So at the very beginning of the trial, well, guess what? She didn't have a ride to the courthouse. She's like, well, I can't be bothered. I'm not going to be there. And of course, that's a problem. She missed her subpoena. And so how did she get to the courthouse? She got a ride from a deputy. You know how those go. They're not doing Uber. Okay. You're right in the back seat when the deputy comes and picks you up. She got a ride back to the courthouse and did not handle it very well. The judge suspected drug use, and said, "Look, I'm gonna hold you. I'm gonna issue a bond, $1,000 bond. If you can pay it, you can get out. But we need you to appear in court, and we want you to testify on Tuesday. So you've got to show up. And if you don't pay the bond, well, of course you're going to show up because you're going to be in the jail, and we'll just bring you over in the paddy wagon." And then you can testify from there, and then we'll release you at that point. And she says, by the way, when you get to jail today, they're just going to have you pee in a cup real quick, and we'll see what happens with, because you've told me there's nothing in your system, and I don't believe you. And the judge was right. There was something in her system. And she said, we would have had the lay witness testify today, this afternoon, if it weren't for the fact that she was high or under the influence of something. That something was in her system. So she'll be in on Tuesday. Judge said meth. Judge said, are you sure you haven't had a little meth? That's what she said. Sure you haven't had a little meth? There's court on Monday, but with this judge, but not for this case. That makes a little more sense. Thank you, Anna Banana, for that. Just a little bit of meth. Judge did not mince any words, and then she sort of laughed about it because everyone knew that, yep, the signs were there. Anyway, please make that a meme. I need that in my life. I'll just post it on Twitter. How about that? I'll post that video. Let's make a post. What's happening? I'm just putting this on X, by the way. That's where it's going to be. It's just a simple post that says, lawyering is hard, like frying pan to the head, hard. Let's see, this is over on Big Deal 1, frying pan, open, post. It's uploading right now. Hang on, 720, let's do 1080. 18%, 32, 38, 45, back down to 31, 45, 50, 60, 87, 99, post. It's up. It's live. There we go. All right. Please go viral, says Kelly Work. All right. Anything else we need to talk about today? It's Friday. It's Friday. I've got a thing tonight. I'm not sure if our court watcher is going to be able to call in. Are you there? Can you hear me? Let's, what's the name on X? Recovery Addict. I think it's at Recovery Addict and the number 2. Because someone else stole the first one. Have we heard from Nicole Rice, Juror? I have not yet. Hey, we've got a call. We've got a call. Kayla, hang on. I've got you right here. Hang on just one second. Hey, Kayla, are you there? Hello?
Yes, I am.
Hey.
Sorry if there's a little bit of road noise.
Oh, you're okay.
Hello?
You're okay. Wonderful. What a day.
That was crazy. That was the gas in the courtroom when he hit his head was wild. I cannot believe he did that. Just the whole day, all of it was interesting.
Yeah, I posted this online, just that part of him hitting him. I may have replayed it like 3 times. So it was bonk, bonk, bonk on his head, and then he stumbles off.
I know.
It was it was wild.
Even the reporters were kind of like giving each other looks around, like, did that really just happen? And I could tell the judge. Oh, go ahead.
There was an objection. I think it was sustained about
it. Yes. And by the end of the day, I could tell she was just so frustrated with the whole situation because they're kind of bickering quite a lot. Even when the cameras aren't rolling, they're bickering quite a lot. So
there was a big win for the defense today with that witness that came back after lunch. They're not getting the testimony in that the towels that were in the washer and dryer, where she says she was down working, where the defendant was, were soaked in gasoline.
Yeah.
And that's not coming in currently, unless the state can pull off some miracle and, get some case law or some other reasoning to bring this in. Doesn't look like it's coming in. I think that's a key piece.
I think so too. And the way the jurors were writing, these jurors are super, super attentive. None of them fell asleep. There's only one that didn't write any notes at all. But he's kind of the canary in the coal mine. If he pops his head up, you usually can tell it's a pretty important piece because everyone will when he does that. Yeah. But I think it's going to matter to this jury for sure because they're very detail-oriented.
Well, we're thinking there's somebody on the jury who's either got legal experience, medical experience, or law enforcement or like courtroom experience.
I would probably, I would agree with something like that or just a professional. They're Juror 4 and Juror 12 are both dressed pretty professionally. Juror 4 is wearing like a sports coat and stuff like that. And those are the two jurors that have had the most interaction, the most questions. Juror 4 literally leans forward when testimony is interesting, and even when it's kind of boring, he's still very much paying attention. Mm-hmm. So I think it's probably those two because those two are the ones that are asking the questions, if I had to guess. But I don't know. It's not super. You can't tell by looking at them at what one it is, I would say. But they're definitely. I could agree with that.
Yeah, it's amazing. I love that the jurors get to ask questions. That is just wonderful. Get to take notes. I think that's the best of both worlds. Couple other things. There was a lay witness issue today. The lady who missed her. She was the one. My understanding, she was the one who called 911. Like the first one of the callers.
Oh, the girlfriend? Okay, yeah. Calhoun, yes.
Okay, so she was one of the people that called 911. If you follow the case chronologically, we should have had her pretty much on day one. And she was subpoenaed by both the state and the defense, and she didn't show up. And so when the police went and got her, which they did, they dragged her into court, and she's like, I couldn't make it, I was busy, I didn't have a car, I was far away, what excuses. The judge, she would have none of it. And ended up issuing a bond, basically saying, I'm taking you into custody. You can get out if you give us $1,000 because we'll hold that $1,000. You're going to come back and get it. I know it's going to be important to you, but you have to be here for Tuesday. And she also asked her, have you had anything, any mind-altering substances recently? And she said, nope, nothing in my system. But they did test her when they took her to the jail, and apparently the results came back positive.
It's positive.
Which is why she's not testifying during the break today, because we had a little bit of a window where it would have been great. I mean, the perfect timing for a witness like that. Wouldn't be very lengthy. Would have been great. She would have been out of jail. Judge says, I would have done that had she not tested positive. So now the long weekend is going to be especially long for her.
Yeah, for sure. Oh, you go ahead. Luckily, the courthouse is right next to it. It's right next to the jail. So just up in the jail, apparently, over the weekend. So.
You sent me the information about the mural in the courthouse, and I looked it up on Google. I'm like, wow, that is quite the mural.
Yes, that courthouse is actually beautiful. The reason I haven't called in the courthouse is because most of it's stone and wood, and it echoes so badly, but it's beautiful. Yeah. The actual courtroom itself's got like 20-foot vaulted ceilings with like this plaster, and it's beautiful. But yes.
When was it built? Is this like a early 1900s?
I think I would have to look it up. I think mid 1800s, maybe late 1800s.
Wow. So I wonder if they'll let me metal detect on the property, because there's probably some cool stuff to find there.
Yeah. Yeah. No, for sure.
Oh,
does anybody want context?
Yes.
Does anybody want context for the area in general,
let us
or
know.
If not, it is very, very rural. It's completely possible that one, there is a lot of small lakes around, so that's probably why they had the boat in the yard. It's not like you're going to take a small boat into Lake Michigan, obviously.
Right.
But when it comes to like first responders and just helping, a lot of the jurors even were nodding to it because it's so rural. Like each property typically has between 10 and 20, 30, 40 acres around this area. A lot of neighbors stick together because it does take time to get help. There aren't as much police and fire around as a larger city and those kind of things. So you do rely on your neighbor a lot. And so a lot of these contexts, that matters, I guess, in this context. As to why the friend was helping with the fire department, even though he wasn't certified and those kind of things.
Yeah, in our case where we had Mr. Violet and Mr. Levesque, the police showed up there in like 2 minutes from 911 call to on scene.
Yeah.
Here, I think it was closer to 7 to 8 minutes, which is still a pretty quick response. But even that was just the first person on scene. It was a while yet before the fire trucks and everything else arrived. So response is slower. That does make sense about the neighbors helping and stepping in. That's something you find a lot in rural communities. With, you know, if somebody's in need, if there's a farmer whose field's on fire or something, or even if there's a farmer who gets injured, it's like the neighbors just step up and help harvest their field. And just like, we help each other here. You know, the We Grow Together slogan, that's a thing. It's not just like, hey, we thought of a cool word to put on our sign. So that is really neat.
Yeah.
It's nice to see that.
Yeah, for sure.
So is this the first day you've been in court ever? I mean, you don't have to tell if you don't want to.
Yeah. You're
an amazing court watcher. Like the details you're giving me on the text messages about the ages and the jurors and the genders and what juror numbers saying what. It's fantastic. I love it. Are you hooked?
Thank you. I am hooked, and I watch you guys and Emily D. Baker and all that kind of stuff. So and Lauren, everyone. So I was excited. I was like, when I first saw it yesterday, when you guys were streaming, I was like, you've got to be kidding me. I literally live right here. I had no idea about the case, even though I watch a lot of this stuff. I had no idea that I was going to retrial and stuff like that. And I have a job where I only work 3 12s a week. And so I was like, I'm off tomorrow. I might as well just go to court. Why not? I'll take advantage of it. And so I might actually, depending on my schedule and how long the trial lasts, next week in the beginning of the week's a little busy, but if it lasts towards the a while longer, I might go to another day or two, which I'll let you guys know about.
That would be awesome. We loved it today. Thank you very much. I appreciate you taking time out and then putting us on the schedule to give us the insight to the things we can't see from this end of the camera. But okay. Thank you so much. Drive safe. Of course. And have yourself a great day.
Thank you.
Thanks, Kayla.
Right. You too. Thank you so much.
Bye.
Yep. Bye.
Awesome. She did a great job. Kayla's fantastic. Appreciate her taking a day out in court today. Yes, I'm looping the video. I just love it. It's looping over here on my on Twitter as well. Anyway, wow, what a day. I have a gig tonight that I've got to get ready for and go to, so we can't hang around too late. This schedule actually works really well for me. If there's anyone else that has questions or something we can talk about that we need to talk about before we break for the weekend, apparently we're not coming back on Monday. Monday might be a bathroom remodel day, or I don't know, maybe I'll just hang out and feed the squirrels. Let's see. Selena K, thanks for the update. You got the appointment with the trauma surgeon next Tuesday. We've been, I sort of feel like I've been in it with you as you've gone through the saga with the knee injury. This hopefully is one of the steps that will get you to full recovery and pain-free. And so our thoughts and prayers are going to be with you. Good luck. Good luck there. Ivan is going to be shorting the Euro, apparently, over the weekend. Good luck. Good luck with that, Ivan. I think you're going to do great. Let's see. Anything else? Are there other trials on Monday? There are a couple other trials about that might be going. So we might do some court hopping on Monday. But support your local crayons. Yes, buy a box of crayons. Color a picture on Monday. We have thunder here in mid-Michigan. We heard some thunder during the court. It was so good. There's the Dr. Murders trial. Is that the Juror one? Tony, thank you very much. We'll see you on Monday. Let's see. Someone mentioned a Juror trial. I'll have to look at that. This trial is probably going to go for at least another week. And and then we have the Karen Reed trial comes up. I know there are lots of things I hate about the Karen Reed trial, but there are also some things I love about it, and I'm very, very tempted to follow it, if nothing else, to be a drama, hopefully a drama-free place to watch it. I know it's asking a lot, but we're looking at that. That case intrigues me, especially with the former juror who's now on her legal team. I've read so many motions in that one, back and forth, both from appellate courts and the judge. I'm interested to see if the state presents the same theory, or if they've come up with a different one that might work better than what they presented the first trial. So we'll see what happens. Of course, as always, we've got other things on the schedule as well. Corey Richens is coming up at the other KR trial. We've got to see if that case gets moved out of Uinta County into Salt Lake County in Utah, which takes it to the capital city. That'll change everything a little bit and probably change the schedule because the availability of the courtrooms is a little bit different. So that might push that out a little bit as well. Selena says, you've been with me since the fall happened while watching your stream. Selena, I'm glad we were able to help in some small way, even if it was just provide a little comfort for you. Is Turek trial in Canton also same investigators? Not sure. A lot of the same names like Proctor in the Turek trial. Let's see. I think that's it. We'll see. We want to keep you guys entertained, and we want to watch a case that's intriguing for all of us. So we'll watch how the schedule comes down. Ask her how the jury is reacting to the nasty lawyer. Lori, you're a little bit behind. We lost her already. But we'll ask her, well, if someone else is able to go and watch court. I know there are a couple other people who've said they might go. Let me know. Lori Daybell is coming up. Yes, Lori Daybell is probably one we won't follow because it's just its own version of crazy that it's going to be frustrating like Daryl Brooks frustrating, I think, is how that's going to be. Let's see. I think that's it. I think that's everything. I think we're ready. 6 Volt, thank you very much. Good to have you here, my friend. To all the mods, thank you very much. Appreciate very much the help and support you give the channel. I could not do this without you. I could not. Thank you so much. The music, please, says Carol. No, not the music, says my opinion. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe. Do we go live again Monday morning? Let's do Monday morning. Might be some court hopping, but we'll be back on Monday morning to see what's happening. Have a great weekend. I've got a gig tonight, and I've got bathroom remodel on Saturday, day off on Sunday, and I'll have to give you an update of how the squirrel and bird situation is going in my yard. This morning when I got up, the 3 squirrels we had before had turned into 8 squirrels, and right before I came in here from lunch, others were crossing the street to come over. So we could have an infestation here anytime now. So it's going to be great. You guys have a great weekend. Be good to each other. We'll see you. Bye-bye.
Because he's the guy.